Welcome. Tonight is the ZBA hearing for Tuesday, April 12th, 2022. The time is currently 6:30. This is a hybrid participation meeting. My name is Lynn Fiddler. I am the chair of the ZBA. And you'll see in front of us, we have a quorum this evening. We have 5 of our full members and 1 associate here this evening. So I'd like to just start off by everybody introducing themselves, please.
Chris Belazos. Larry Keane.
Lynn Fiddler.
Heidi Conway.
Brian Murphy.
Steve Feeney.
All righty. So tonight is a hybrid participation meeting. Every effort will be made to ensure that members of the public can adequately access the proceedings to the best of our technical abilities. And despite our best efforts, this meeting may be viewed as a video recording on Marshfield Community Television website, marshfieldtv.org. And a transcript or other comprehensive record of the meeting will be available as soon as possible after the meeting. Please note that while an option for remote attendance and or participation is being provided as a courtesy to the public, the meeting hearing will not be suspended or terminated if technological problems interrupt the virtual broadcast unless required by law. I'd like to remind everybody, if you're dialing in, you must use *6 to be heard, and then again *6 to unmute yourself. Tonight's meeting ID is 898-0148-1329, passcode 541929. This evening we have a packed agenda. I'm going to just do a little housekeeping before we get started. If the board members would, is there anything you would like to say before we get started, Nancy? Are we good? Everything else? Okay. So I'd like to obviously bring this meeting to order. Do I have a second?
Second.
Second by Heidi Conway. All those in favor?
Aye. Chris Belazos. Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Steve Feeney, aye.
Alrighty. So the continued hearings to date certain of this evening of 4/12/2022. This was a hearing that was read into the record at a previous date. This is a case 21-90 for Gabrielle and Helene Gomes, and this is 76 Caroline Circle. The applicant has requested a continuance to May 24th. I believe they're working through Concom, and I would like the board to acknowledge that, and I would like to grant this continuance if I have a second.
Second.
Second by Heidi Conway. All those in favor of granting the continuance to May 24th at a time certain of 6:30.
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Steve Feeney, aye.
Alrighty. So that is, okay. So I'm going to give the board and the public a little bit of a heads up of what we're doing this evening. So we had another case which was 125 Surf Avenue, and this applicant has been in front of this board multiple times, and that's case 22-08. So we have 2 cases in continued hearings, 2208 and 2208A. Those are both continued hearings. I'd like to start with that hearing, and then this evening they had also come in front of us and had filled out a new application for 2208B, which is the 3rd listed in new hearings this evening. So that's, right now we're looking at 2208, 2208A, and 2208B that has not been written into the record. So I'd like to clean that up before we get started, and at that point we'll just go through our agenda case by case. So oh, and the other thing is, I don't know if you're aware of this, but I am running for select board for the town of Marshfield. So this evening I will not be hearing any cases that regard anything that I feel that it will be continued. So this evening I will not be voting on Kilcoyne, and Brian Murphy will take my place as vice chair. And also there's a solar hearing, and I will not be doing that either. But I'll just dismiss myself and come back in. Alrighty, so do we have the applicant here this evening for 125 Surf Ave or their representative?
I texted him. I think he's still
Right
in the
here.
hallway.
Oh, okay. And I have a little bit of a allergy thing going on, so my voice is a little weird.
Hi.
Good evening.
Good evening.
Okay, so I'm going to read the new variance into the record, and then we'll get right to this. All right. So this is case 2208B. Maureen C.G. Cook, the petitioner is seeking a variance in accordance with 305-10.11 of the Marshfield Municipal Code for relief from 305-6.02 for 2.2 feet of the proposed 6-foot wide deck that would extend beyond the allowable 13-foot setback for a deck over 4 feet high. It would have a landing and stairs at each end of the deck on the property located at 125 Surf Avenue, which is further identified on the assessor's maps as being on parcel K11-2407 and is located in an R3 zoning district. So if you would identify yourself for the record, and then I did mention to the board before I read that into it, a little bit of the history of what we have going on, but if you'd like to clarify it for the board.
Excellent, yes. My name is Richard Savant with Stenbeck and Taylor, representing Maureen Cook on this project. So based on our last hearing, we are before you tonight. One of the items is this variance request for the deck on the Constitution Road frontage of the property. Since we last met, we have revised the deck size. It used to be an 8-foot deck. It is now a 6-foot deck, which we're seeking a 2.2-foot variance beyond the allowable 13 feet for the front setback. I've done the best I could with the variance request. We know our biggest issue here is the wet area and the low topography in the back, which doesn't allow good access to that rear stairway. So the applicant is really desiring to have this wraparound deck for family purposes, that they need a connection from the front to the rear door, and this deck would provide that. Again, this deck is about 8.5 feet off the ground. The way it is, it's elevated on at the first floor, but it's supported by posts which support this deck. So again, yeah, it's a 2.2-foot variance that we're seeking beyond 2.2 additional feet beyond the allowable 13, because the deck is over 4 feet off the ground. And that's essentially what we're seeking the variance for, is that. And I'll do my best to answer any questions you might have.
Okay, so a little bit of the history as far as I remember on this particular project was there was a stop work order originally, and
Right.
just give the board
Yes, of course,
a little
yes.
refresher.
There was
It's been
some
a while.
work that was begun. I was involved in the project at that time, but basically the building inspector got involved, and the amount of work that was being done, because the property is in a flood zone, it was required to be elevated to meet flood regulations, which placed the house about 8.5 feet off the ground, or above the grade that it used to be. So now we have the elevated structure. If it was still on the ground, this deck would make the requirement for halfway into the setback for a deck below 4 feet in height. So it was something that they had originally hoped to do. Now we're up in the air, so we'd like to do the same type of arrangement, but so we are now elevated to meet the FEMA flood zone in this area, which puts us in this situation where we cannot make the setback to the street.
And you've got a handicapped person in the house?
Yes, it's a mother's home, family home. She's on a walker, has difficulty getting around, and we went back and forth about the width of this deck and looking at what would be wide enough for her to safely get around and allow for safe passage from front to the rear there.
And the handicap would be affected by the pooling water in the conditions on the
The
ground?
rear yard is a very wet area. It's often never dry. That is correct.
Actually, if I remember correctly, we had 2 handicapped or 2 elderly people living.
Yeah, the sister, is,
So there were 2 family members.
that is
in
correct.
this.
Yep.
Okay.
She's special needs, actually, special needs, but
Yes.
she's probably not.
Could you
And
please
Maureen, I'm sorry, I
identify,
didn't know you
excuse
were
me?
here.
Hi.
Nice.
Hi, no, it's all right, we're just doing the due diligence. Would you identify yourself for the record?
Maureen Cook,
Okay.
I'm the owner of 125.
I was aware of it, not everybody. Okay.
Sorry.
No, that's okay.
I thought by now you'd know me.
Well, I do, but not everybody in the room does.
Yeah, so my sister's special needs, so she doesn't need a walker, but is very unsteady on her feet. And my mom needs a walker.
Okay. We also talked about the actual curb on the pavement and the edge of pavement in relationship to
Yes.
the actual property boundary and where this sits, and there is a little bit cushion, a little bit of a cushion. going
Actually,
there.
it's like 20 feet from your foundation to
Yes.
where the road is actually traveled.
Okay.
Yeah, that is correct. I'd also like to point out, I know it has nothing to do with the setbacks, but that existing step that was on the front of the house was at 10.2 feet off of that street line. Just for safety reasons, I just wanted to mention that. I know it doesn't apply, but we're actually further off the road than that existing stair has been historically for a lot of years and never presented any safety problems or anything.
In this situation you find yourself in now came from you doing a substantial renovation to the property, so it forced you into
That is correct.
elevating it to this.
That is correct.
Any more comments from the board?
I am good.
So we were at 8, we're down to 6.2, right? Repeat.
That is
That's
correct.
right.
6-foot deck
I
proposed.
just have, I don't
Yep.
have the new, I'm looking at the old one.
Yep. We reduced it 2 feet from 8 feet down to 6 feet. We looked at 5, but it just wasn't feasible for a swinging door on the front steps and everything. It just didn't work.
So would you just, the driveway will remain, the brick patio will remain?
Yes, that's no proposed changes there. That's where we provide the good dry access on that end with that landing that goes
yeah.
down to the ground. So we can get from the vehicles with a good hard surface onto the deck and allow them to walk around to the rear and enjoy that rear porch that's there and the rear access of the house.
Is this shed still there?
Yes.
Okay, so this board would not endorse that shed. Let me just look at this. Any comments, Brian? Heidi? No? Any comments from the public? If you're dialing in, you need to press *6 to be heard. Are you good? Are you all set?
Yeah,
You just
end of a
wanna see
long
this?
road
This has
for
been a long-
Maureen.
This is what, the fourth hearing we've had with these
So
guys?
I think the fourth hearing,
Okay.
we
All
had
right.
stop work orders, notice of violation, removal of
I know that you
contractors,
worked
all
very hard
sorts of
with
stuff.
Andrew, so
Yeah.
Andrew's been amazing.
we appreciate that, yes. So, okay.
Yeah, oh, sorry, yeah, good point. The stop work order was not her fault. It was her contractor's fault. Her contractor put her in this situation.
Okay,
I would definitely say that.
okay, thank you. Well, are we okay to close? Everybody good? All right. So as I close, I'm going to close each of these systematically. I'm going to start with case 2208, which was the very first hearing that we listened to. I'd like to make a motion to close case 2208. Do I have a second?
Second.
Second by Heidi Conway. All those in favor?
Chris Bellis, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Okay, and I'm going to close case 2208A, which was when we added 1301C, .1 into the mix. Do I have a second?
Second.
Chris Bellis, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
All right. I'd like to make a motion to close 2208B, again for 125 Surf Ave, and that is for the relief of the variance for 305-6.02 for the 2.2 feet. Do I have a second?
Second.
Second by Heidi Conway.
Chris Bellis, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Alrighty. So, let's look at. To make sure I have everything as we're going. So we are dealing with the Inland Wetland Overlay District. Would the board like to deliberate or move to the end, or do you want me to just finish this up right away? Guys?
I'm all set.
I feel like we've
We,
discussed it pretty well.
okay, all right. So the conditions and circumstances are unique to the applicant's lot. This is in relationship to 2208B. This has to do with the variance. So why don't we go backwards and start there with the variance first. Conditions and circumstances are unique to the applicant's lot, structure, or building, and do not apply to the neighboring land structures or buildings in the same district. Number two, strict application provision of this bylaw would deprive the applicant of reasonable use of the lot, structure, or buildings in a manner equivalent to the use permitted to be made by other owners of neighboring land structures or buildings in the same district. And again, the unique conditions and circumstances are not the result of actions of the applicant taken subsequent to the adoption of the bylaw. Relief, if approved, will not cause substantial detriment to the public good or impair the purposes and intent of this bylaw. Relief, if approved, will not constitute a grant of special privilege inconsistent with the limitations upon other properties in the district. So that is what we're dealing with, and I would like to make a motion to grant the special permit acknowledging the land in the rear of this property is wet. And that those conditions, unless the board has anything else to add, conditions and circumstances of the lot. Okay, all right. Make a motion to grant the special, grant the variance. Do I have a second? Second. Second by Heidi Conway. All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Brian Murphy, aye.
I'd like to make a motion to grant the special permit in accordance with 305-10.10, 905-9.02, 305-9.02C. Acknowledging actually as well that we already did talk about this, that the shed will not be endorsed by the board.
And just noting then that the, what's on the agenda is a different dimension than what we're approving.
Yeah, that the,
Yeah.
It's 6 by 45, not 8.
I'm sorry, wait a minute. 6 by 45 was the change on 2208.
And the 6 by 32.
6 by 32. Yeah. Is it on the first one? Is it on the B?
Yeah, it's correct on the B.
It's correct on B, so I'm going to read off of that. Thank you. Okay. Is the board in agreement that 10.10, the criteria for 10.10 for a special permit have been met? I'm just looking through it quickly. Use extension request. All right. I'd like to make a motion to grant the special permit in accordance with the 305-10.10, 305-9.02B, 305-9.02C, and 305-13.01C.1 of the of our bylaws. Do I have a second? Second. Second by Heidi Conway. All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Okay. So we are all set.
Excellent.
All set. Thank you.
Thank you very much. Thanks for your time and help with all this, with everybody. Andrew,
Yeah, no problem.
thank you.
Thank you very much.
Thank you, good luck. Good luck. I hope you'll get on that deck by the fall.
Exactly.
Thanks again. Have a great night.
Good night.
Great.
So board members, we're going to go to the, our regular scheduled, and start with 2231, and then we'll just go right down through the new hearings and finish up with the other continued hearings to date. You're gonna leave this one? Okay. So Brian is recused from case 22-31, and Chris, you will take his vote.
I'll take it.
All righty? All right. Do we have the applicant here for 1 Seaview Avenue?
They're on Zoom.
Are they on Zoom?
1 Seaview Avenue?
Scott,
Andrew?
are you representing anybody?
He's talking, we can't hear him.
Is the volume up on that TV?
Looks like he's muted.
Scott, you need to unmute yourself?
He's not muted. Is the volume up?
This is the first time. John Cusick, can you hear my voice?
Scott, can you talk again?
Yeah, can you hear me?
Yes, we can. Now we can hear you. Thank you.
Oh, really?
All right.
Again, Scott Bernara with Grady Consulting, representing the applicant.
Okay, Scott, I'm going to read this into the record and we'll get started.
Okay, thank you.
Alrighty, thank you. 2231, Andrew, how do you pronounce the last name? Ox?
I believe it's Oaks.
Oaks?
I believe it's Oaks.
Okay, thank you. The petitioner is seeking a special permit in accordance with 305-9.02C and 305-10.12 of the Marshfield Municipal Code to construct a 12.5 foot by 18.3 foot and 30 foot by 18 foot two-story addition, a 10 foot by 21 foot deck, and a 4.8 by 9 foot covered entrance on the property located at 1 Seaview Avenue, which is further identified on the assessor's maps as being on parcel G160701 and is located in an R1 zoning district. So Andrew, we're going to start with the application and then we'll get right to your project. So why don't you tell me what you have planned? Thanks, Scott. Scott?
Yep.
Okay.
All right, yep. So we're seeking a special permit for the alteration or extension of pre-existing non-conforming structure. The existing structure is, I believe, a 3-family dwelling, and it conforms to the front setback for Summer Street, the side setback and the rear setback, but it is non-conforming to the front setback for Seaview Avenue. The addition that they're proposing is a 2-story addition. Again, it will be conforming to the front setback for Summer Street, the side setback and the rear setback, but not the front setback to Seaview Avenue. The setback will not be more non-conforming than what currently exists. There's also a proposed covered entrance to the front of the existing dwelling. We have elected not to request a variance for that work. We believe the covered entrance is not more detrimental to the neighborhood, as covered entrances are common with homes in the neighborhood and provides protection with weather. Also like to reference a court case decision from 2019, a very similar case, the Bellata versus Brookline Zoning Board of Appeals. This also recently been upheld by this board, case number 21-80 on 60 Montana Street, which is a similar situation, just a covered entrance. I'd be happy to answer any questions.
So Andrew, can you just, since we're talking about the front setback, let's just jump right to that. So just expand in on that front.
Certainly.
Okay. So
So there currently exists a 20-foot setback to the existing stairs. And what they're proposing is a covered entrance that would be 17.4 feet.
So it's not 17.4, correct? It's.
Well, to the steps, it would
But
20 to the
overhang of the
overhang,
roof is
correct.
what I'm thinking about.
So it's a little beyond that with the existing steps, but it's about that to the bottom of the steps. This is a front setback in an R1, so it's required to be 40 feet. So they're non-conforming already in that regard. So that's why they're only seeking a special permit under Belalta and not a variance, as they're extending an existing non-conformity.
So it wouldn't have to go to 20.6?
Pardon me? It would,
It wouldn't have to go to 20.6 on that overhang?
nope. No, the existing, like the required setback is 40 feet. So the house is already non-conforming in that regard.
Correct.
So they're extending that non-conformity via special permit
Right.
under the Belalta standard.
Okay, okay. And do we have the deed for this project?
Yes.
I believe so.
We do?
It should be in there. I think there's a big packet.
It's in the packet.
Yes.
It's in the back?
It should be
Okay,
right after.
thank you.
Yep. It's above
Corner
that.
lot. Any questions from the board?
No, thank you.
I'm good.
Any questions from the public? Anything you'd like to add, Scott, before we close?
No, thank you.
The Board of Health weighed in on this. You have a 4-bedroom septic field. Did the planning?
Yeah.
Did planning's
But I did not have comments on that.
Planning didn't have comments on it. Alrighty. I'd like to make a motion to close case 22-31. Do I have a second?
Second.
Second by Heidi Conway. Make sure I have everything. So again, this lot is non-conforming to the lot area and the front yard setback. Before granting the special permit, items 1 through 10 that I just reviewed for the previous hearing, and whether or not the shed, is the shed being removed? Scott, is the shed being removed?
I believe the intent is for it to stay.
Okay.
So long as the shed been there at one time?
Do you know how long the shed's been there?
No, I do not.
So this board will not endorse the shed?
Okay.
Okay. So I'd like to make a motion to close case 2231. Do I have a second?
Second.
Second by Heidi Conway. All those in favor?
Chris Bellows, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Patty Conway, aye.
All right, so this hearing is closed. I'd like to make a motion to grant the case 2231 for 1 Seaview, acknowledging that the board will not endorse the shed and that items 1 through 10 are applied for our special permit. All right. Do I have a second to grant this special permit?
Second.
Second by Heidi Conway. All those in favor?
Chris Bellows, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Patty Conway, aye.
All right. So this case is closed. Thank you, Scott, for your time.
Thank you.
All right, have a nice evening.
You as well.
All right, do we have the applicant here for case 2232? Do we have the applicant? Oh, I'm
I
sorry.
have my,
I didn't know if there was someone else that was joining you and you were just a sideline. I'm going to,
Did they switch?
All right, hello, I'm Brian Murphy. I'll be the hearing officer for this hearing. 22-32 James J. Kilcoyne Jr. In accordance with 305-10.09 of the Marshfield Municipal Code, the petitioner is appealing the decision of the building commissioner concerning enforcement of the town of Marshfield zoning bylaw and involving unpermitted development activity, asserted violations of the zoning bylaw, and asserted violations of existing zoning permits, and approvals in the floodplain, coastal wetlands, and inland wetlands zoning districts on the property located at 51 North River Drive, which is further identified on the assessor's maps as being on parcel E20-03-06, and is located in the R1 zoning district, the coastal wetlands overlay district, and inland wetlands overlay districts.
Thank you,
What do
Mr.
you
Chair. Good evening, everyone. My name is Adam Brodsky. I'm an environmental and land use lawyer, and I represent James Kilcoyne. Mr. Kilcoyne is the trustee of the James J. Coyne Jr. Living Trust, which owns the property at 51 North River Drive. And I should preface my remarks by saying I come in peace this evening, and just want to give you some context so you understand why this appeal was filed. Mr. Kilcoyne is concerned that he's been singled out for disparate treatment and not being treated as any other property owner in the town of Marshfield. In his experience as a former member of the Conservation Commission, and in my experience also, typically if there are issues regarding enforcement, the property owner is informed of those issues and given an opportunity to address them. And Mr. Kilcoyne believes that that did not occur in this instance. This matter went straight to enforcement with the issuance of a notice of violation. And I just want to give you a context for that. But regardless, Mr. Kilcoyne is prepared to do what the board requires of him in order to bring this property into compliance. Again, to give this some context, Mr. Kilcoyne spent literally years obtaining the necessary permits for his pier and timber walkway on the property, including an order of conditions from the Conservation Commission, a special permit from the Zoning Board of Appeals, because portions of that were located within the Wetland Overlay District. He's been to the North River Commission. He's obtained multiple Chapter 91 licenses for the structure, and in connection with that, actually obtained municipal zoning certificates from the building department, both for the timber pier in 2014 and the later changes to the pier and the floats in 2018. He's also obtained authorization from the Army Corps of Engineers. And so he has done his very level best to comply with all laws in designing and permitting these structures. What he really wanted was an independent review by the board of the issues, given his concerns with process more than anything else. And so he has three major objectives. The first is that there were a number of allegations concerning issues involving the Wetlands Protection Act and the Conservation Commission that aren't really the province of the building department or this board. And so those issues should not be properly the subject of a notice of violation. And Mr. Kilcoyne is already engaged with the Conservation Commission, is in discussions with whatever they require in order to address the additional features that were alleged not to have been permitted, and is scheduled, I believe, to be in front of the Conservation Commission shortly. So I wanted to assure the board that those issues are being addressed and shouldn't really be the subject of a notice of violation of this sort. Second, he is looking for the board to give direction and, in fact, directives on whether he needs to file an after-the-fact building permit for the Ramada. That's the landscape feature that we provide you with plans that really is the subject of much of this dispute. It's essentially a roof on 4 5-by-5-inch posts that sits over a portion of the timber pier. That was installed in late 2016. There also is a suggestion that the construction of the timber walkway itself, which was built in 2015, may need a building permit. And before I begin, I should note that the reason I'm here by myself and Mr. Kilcoyne is not here is that he's home ill. I was hoping that he would join us via Zoom, but it doesn't look like he's attending. So I just wanted you to know that he's not here not because of any disinterest in this, but he fell ill this last several days. So if you ultimately determine that Mr. Kilcoyne needs to file an after-the-fact building permit for the Ramada, he's more than prepared to do so. Again, if you think that he needs to file an after-the-fact building permit for the actual timber walkway that leads to the pier in 2015, he's also prepared to do so. I've suggested there are sound arguments under both the building code and your zoning bylaw why you wouldn't necessarily require a building permit for these types of structures, but that's an issue that we'll defer to the board on. As I mentioned, the Ramada, it's sometimes called the pavilion, is literally a roof on 4 legs that sits over a portion of the timber walkway. It's an open-sided structure without walls. It's not used for storage. It doesn't provide shelter for anything or anyone except during the summer, where if you were to stand or sit underneath it, you would have some shade. Again, if the board determines that you need a building permit for that structure, Mr. Kilcoyne will comply. He just wants to make sure that the rules are being applied across the board. So if anyone else in town has similar landscaping features, similar trellises, arbors, that they would also have to get building permits, presumably, under this rationale. Similarly, the timber walkway, it's not a building regulated under the building code. It's simply to allow facility to obtain access to the water. And what the board may or may not know is that the construction standards for these types of structures are actually provided in the DEP waterway regulations. They have strict construction standards for piers and access walkways. That's one of the reasons why Mr. Kilcoyne was required to obtain Chapter 9 licenses for these various structures. I'm candidly not sure there are any construction standards for timber walkways in the building code. I'll defer to the building commissioner on that. That's why I presume DEP regulates those with their own engineering standards. However, if ultimately at the end of the day the board wishes him to file an after-fact building permit application, he's prepared to do so. The third thing that Mr. Kilcoyne is asking for, the third objective he's trying to achieve here, is confirmation that he doesn't need to modify his existing floodplain special permit or obtain a floodplain permit under Article 15, Section 305, 15.04 for the Ramada. And I should note that the Ramada sits over a section of the timber walkway that was expanded, so there's a little square section, and the Ramada sits above that. If you read my materials, you'll know that square section was approved by Jay Winnemer as a field change in connection with the orders of conditions for the project. In any event, at the time that he installed the Ramada in 2016, he believed that the FEMA floodplain was an AE elevation 9, which is what it was historically at, and the Ramada was located far outside of the FEMA floodplain elevation at that time. The building commissioners brought to our attention that the floodplain map had changed. There's a revised floodplain map dated November 4, 2016, that actually changed the floodplain elevation to elevation 16, that would then put the Ramada and the wooden platform into the floodplain. Mr. Kilcoyne can't confirm exactly when the Ramada's installed. It was purchased in something like October of 2016, but he doesn't not have the exact date when the Ramada was installed. It was installed shortly thereafter, so I can't pinpoint it. Again, if you want Mr. Kilcoyne to seek a modification of his existing, special permit for the Ramada, he's prepared to do so. I'd respectfully suggest I don't think that's necessary. I mean, this is not a building. There's no concerns with the displacement of flood waters associated with 4 5-inch by 5-inch posts that would ostensibly sit within the floodplain. This structure is not going to displace floodwaters onto any other property. It's located entirely within Mr. Kilcoyne's property. And as I said, the floodplain mapping changed at or about the time that this was installed. So we respectfully suggest that's perhaps a pun intended bridge too far to ask Mr. Kilcoyne to do that, but if that's the board's wishes, he will seek a modification for that. And then with respect to the floodplain permit, that's the provision in the bylaw that affords you're supposed to go to the building commissioner for a floodplain permit. I think historically it hasn't been applied, but may be under the current building commissioner. However, there's a very specific definition for structures regulated under that provision of your zoning bylaw, and the definition of structure is a walled and roofed building, which makes perfect sense. So if you're building a building that's got habitable space, or a building that may contain items for storage, you want to ensure flood compliance. You're concerned for public safety. You're concerned that the building won't be destroyed in flooding. Again, the Ramada is not a walled building, so I don't believe it meets the technical definition of a structure as that's specifically defined in that particular section of the zoning bylaws. And so that's all that Mr. Kilcoyne is trying to achieve this evening. There were a couple of extraneous housekeeping issues that he's already addressed. For example, the ZBA special permit decision, for whatever reason, was never recorded. We actually were able to locate the original copy, and that has been recorded. Mr. Kilcoyne has provided an as-built plan to the ZBA to conform to the requirements for an as-built plan for that special permit. And again, just to bring things full circle, all Mr. Kilcoyne is asking is to be treated like any other property owner in the town. And he will defer to the board's decision as to what he needs to do to bring these issues into conformance. So I'm happy to answer any questions you may have.
Andrew, would you like to expand or?
I mean, pretty much everything I have to say about it has already been entered into the record as far as the notice of violation, the response to the attorney's response to the violation, and the notes that I provided to the board concerning what was discovered on the property. As far as treating Mr. Kilcoyne like any other resident, this is a notice of violation. It's not a fine or anything like that. So it is a notification to a resident that there is a zoning or floodplain violation on their property. It's required by law to do that, by Chapter 48 zoning law. It's required by the Marshfield zoning bylaw. It's required by the Marshfield floodplain bylaw. So I received the request for enforcement. I investigated. I found a violation. There were instances where, because of the way that the notification of this violation happened through the Conservation Commission originally, in which I was notified, and there were emails sent around, and I do know that Mr. Kilcoyne he was aware of these allegations for months before I sent a notice of violation, and claimed that there weren't any violations on several occasions. So as far as that being notified, he was aware that it was out there. And the notice of violation is just that, it is a notice. And it's the same way I treat every other resident. When there's a request for enforcement, generally what I do is send a notice of violation first. It establishes a timeline. What I found is in the past when people, former commissioners have done notices of, or not done notices of violation. And I don't want to take it deep way back in history the way it's been done before, but, they wouldn't follow through on things because they would start with a phone call, or they would start with a meeting, and there was no record. There was no written record. There was no timeline of starting anything, and things didn't get followed through on. So what I've found is through the various trainings of becoming a building official is the importance of establishing a timeline and to follow the legal letter of writing these notices of violation, which is to inform them of the violation, to cite the actual code that's being violated, to present an opportunity of how to remedy that violation, and to give them the information on how to appeal that violation. And then I always offer an opportunity to call and meet with me to discuss it, in which usually the resident does. And we meet and discuss it, and maybe some of those violations are addressed during that meeting, and they can explain things, or we can investigate it and find out that, okay, I was wrong about something, and this is a pre-existing non-conforming situation, or whatever it may be. But that is how I treat normal violations. And we had an applicant in here tonight that started with a stop work order and just went through the process. And that's all I've asked here.
Andrew, in your opinion, what would you need to happen to cure the violations?
So they've got several. One is a violation of the existing special permit and variance, in which, first of all, they were never recorded when they were supposed to be. I understand that they have been recorded now, but what I said in the letter was that's up to the ZBA and obviously the advice of town council, how your rights to those variance and special permit, which technically have lapsed, how those rights are reestablished. Is them recording it at this stage, several years later, is that enough for the ZBA to approve, those rights to be reestablished, or do they need to reapply in some way? I don't know. That's why I put it to the ZBA, and I requested that as part of resolving the resolution, they go to the ZBA to reestablish their rights. So that's one. Then they violated the special permit because they altered the dock beyond what was approved in the special permit. So it's an alteration of that structure that wasn't approved in writing, which was the way it was supposed to be approved in conservation and the way it was supposed to be approved in ZBA. So that right there was the violation of just doing the platform off to the side. That should have gone to ZBA for a modification of special permit. So you've got that situation. Then you get into the gazebo or ramada, as they're calling it. I understand that they're saying it's not attached to the dock and the platform, and it's actually posts that sit outside of it. From a zoning standpoint, from the zoning bylaw, that is a structure that requires a permit and requires a special permit through the ZBA because it's in the inland wetlands district. So, so that you have that aspect of it. On top of that, it's in the flood zone, or when it was constructed, it was in the flood zone, the ramada structure. So when you talk about floodplain permits, it's the way it has always been treated is it's a permit for any development activity in flood zone. So it's not necessarily just construction of structures. It's any development activity, which is any changes to improved or unimproved real estate. among a number of other things, but that's really what it comes down to. So really what it comes down to is any permits for development activity that are issued by any state, local, or federal entity in a flood zone are considered a floodplain permit, because it's a permit that's issued for a development activity in a flood zone. And as floodplain administrator, it's my role to make sure that those permits, whether they be state, federal, or local, are being applied for and being received for any development activity in a flood zone. Now, that has always been the role of the floodplain administrator. But until the most recent years, when the town has really put an emphasis on the CRS program and our adherence to the CRS program and our participation in that, and increasing our rating to the point where we're the #1 rated town in the state of Massachusetts. That's become important, and part of that is ensuring that these permits are followed through on. And so it's written into our bylaw, into the zoning bylaw, that if there is a violation of any of these state, federal, or local permits, and a request for enforcement is written to the floodplain administrator, which the building commissioner is determined to be the floodplain administrator, that I should respond in the same exact way that I responded to any other zoning violation, which is a notice of violation. So when they violated the conditions of the order of conditions, which was to, first of all, obtain all subsequent permits, which they didn't do, and also to any modification needs to be submitted in writing and approved by the commission, which this was a undocumented field change. So we can say that, that was an undocumented verbal field change, but we have no record of that for something that required multiple boards to issue a permit on. The other thing is, even if the Ramada, being 4 posts, 5x5 posts, a structure placed into a wetlands, that would require a notice of intent at the or an RDA with the Conservation Commission, because you're doing a subsurface disturbance of soil in a flagged wetlands, where you're putting a 5x5 post into a flagged wetlands. So as floodplain administrator, that's activity is happening in a flood zone. So it's my duty to follow through on that that notice of violation. In regards, so what I do is notify the Conservation Commission and the DEP that there's a violation on their orders of conditions. I'm not going to go and pursue fines or anything through that, but it's my duty to inform the permitting body that there's a violation of their standing orders or their regulations.
So in regards to the last issue, the floodplain violation, what issue is before this board to determine relative to that? Is there a cure that we need to address, or is that with conservation?
I don't know. So there's nothing that you need to address other than the fact that the applicant is challenging my authority to address those violations. That seems to be what the appeal is. I would seek clarification from Attorney Brodsky on that, but it seems to be that that's the question, is my authority to enforce or even notify of a violation on an order of conditions in a flood zone.
Do you agree, sir?
I respectfully disagree. The building commissioner has jurisdiction in enforcement to enforce your floodplain bylaw, the floodplain permit bylaw. I respectfully disagree with the building commissioner that the Ramada is subject to that bylaw, because as I mentioned, there are 2 activities. The building commissioner is correct. One are the regulation of structures, and the other is the development of land. I'd respectfully suggest that since the building department's and the building commissioner's view is that this is a structure for all of the purposes, including a building permit, that it should be defined as a structure under the floodplain permit bylaw and shouldn't be considered development of land. Development of land is, the ordinary meaning is you're going out and you're grading. You're actually making alterations to the land. What we're talking about is the installation of the Ramada, which is clearly a structure. And I just want to remind the board that at the time that it was purchased and installed, you had a transition period with a change of maps. I'm being completely honest with the board. I can't tell you the specific date that the Ramada was installed, but that floodplain went from elevation 9 to elevation 16. So it went from being outside the floodplain to, on a particular date, being within the floodplain.
But you can tell us when the floodplain changed.
Yes, well, I know the date of the floodplain map, but I can't tell you in relation to that.
Tell us the date of the floodplain map.
It would have been, I believe it's retroactive to the approval at town meeting, and I'll defer to town council on when that was done. I had that information here, I don't have it at the tip of my tongue. But as I said, regardless, and I should note that it's not located within any vegetated wetlands. The only wetland resource area would be floodplain. And we're not contesting that it's not located presently within the floodplain. So with respect to that particular issue that you asked me about, I don't believe that the installation of the Ramada is either a structure as defined under the the floodplain permit bylaw, or is what was intended by the word development in that. Because if development is now going to include anything relating to land, then every single project, presumably within the floodplain, that comes in front of any board would need a floodplain permit. I don't think the intention of that's what the intention, I believe the intention was that, walled structures would need a floodplain permit, and/or if you're altering that land, you're developing that actual real property within the floodplain district that would change floodplain patterns, that would be what's regulated. With respect to what permitting was necessary on the wetland side, again, I do not believe that the building commissioner has any authority whatsoever to address those issues respectfully. That's purely the province of the Conservation Commission. And again, with respect to the wooden platform, that was approved as a field change by Mr. Wenever, who was the conservation agent at the time. And we have said that we don't have an authorization for the Ramada. I think the argument or the discussion with the Conservation Commission is whether placing 4 posts with a roof structure constitutes an alteration that's regulated under the State Wetlands Protection Act. But that's the conversation Mr. Kilcoyne is having with the Conservation Commission. And if that he requires something, and I don't think it's going to result in either a requirement of a notice of intent or a request for determination of applicability. As you know, the Conservation Commission has essentially permits for de minimis activities. And if anything is required, I believe that this will be a de minimis activity. I think the problem here is again, I'm not challenging the building commissioner's view of the world or how he wishes to run his department, but these things shouldn't be addressed retroactively. If the town in 2014 and 2016 did things differently, the landowner shouldn't be penalized for the changes in how the town wishes to handle matters going forward. And I think you're seeing a little bit of that right now.
Can I comment on that real quick? So let's just, when we talk about going back in history, right? We do have a 10-year statute of limitations on zoning violations. That's been pretty established. As far as flood zones changing and map changes, that happens every few years, and that was not unique to this parcel. That was across the board. People's flood zones changed from 2012 maps to 2016 maps, went from A zones to VE zones. They got elevated from 10 feet to 16 feet all over town. It was, people all over town were going crazy. So that's not a unique situation. The fact that it got put into the flood zone, and then even in 2020, when a lot of other things were removed from the flood zone, when we did a letter of map revision, that area remained in the flood zone, is the only reason why the floodplain bylaw applies in this area. Otherwise, this would be almost entirely a conservation matter, with exception of the fact that if you look at it from a zoning bylaw, take away all the flood zone stuff, you look at it from a zoning bylaw. This is a structure, as defined in the zoning bylaw, placed in the inland wetlands district. So that right there requires a special permit. So, I mean, that's, if you want to look at it from a strict zoning standpoint, the extension of the pier into the platform required a modification of special permit because it was a modification beyond what was approved at the board. And the now separate, apparently, structure outside of the footprint of the pier and the platform on its own independent support structure is a structure under the zoning bylaw in the inland wetlands district. And if we had permitted it properly, would have required that all other permits be sought from all other boards, which would have been the Conservation Commission, would have had at very least done a request for determination of applicability, at which case they would have given it either a positive or negative determination where it would have needed an NOI, or they would have granted it at a de minimis activity. But none of that happened.
Bob, do you want to weigh in on this?
Sure. So, Chris, in response to your question, floodplain zoning has existed since 2006. It's been amended in 2013, 15, 16, 21, all those years. There have been tweaks, usually to adopt new maps, sometimes to make some bylaw changes, but not substantive changes. So it dates all the way back to 2006. In response to kind of what I've heard tonight, it's my opinion that the original special permit and variance did not lapse. They were exercised, they were substantially exercised. I do think that the conditions of the special permit and variance required them to be recorded. They have been recorded. They should have been recorded a long time ago, but that's a moot issue as far as I'm concerned. The structures were built. The dock was built. There's an as-built plan. So as far as I'm concerned, those were exercised and have not lapsed. So I may slightly disagree with the building commissioner on that. In terms of what's been constructed and what was approved, I do think that what exists out there today is different than what was originally shown on the approved plans. And I believe that in most cases, when we are faced with similar circumstances, we're typically dealing with houses and maybe a deck or things like that. The board has traditionally looked at those types of issues as minor modifications and not material modifications because they don't require any additional relief. I always wanted to know what Ramada Inn stood for, and I now know it well because of this case, so I want to thank Attorney Brodsky. Never paid much attention to it until...
Yes, I did not know what the word meant also.
But as I know it, this is a pavilion.
That's why they have them out
It
front.
has a fixed roof and 4 posts or a gazebo, so that's what it is more familiar to me with as it is. And it's my opinion that this required a building permit under our bylaw. And, would this be the first building that was built in Marshfield without a permit? It would not. It probably exists. You're constantly faced with shed issues. As Andrew could tell you, probably there's probably many cases where people haven't applied and got the appropriate permits for sheds. So I think this would require a building permit. It's a structure that's greater than 64 square feet. And although all buildings are structures, not all structures are buildings. I'm not sure if that makes a big difference, but this clearly required a building permit.
Bob, may I just ask you a quick question about that?
Yep.
So as far as a building permit for a dock, I understand that previous building commissioners did not require, or were not asking for building permits for docks. Is this going to mean that I'm going to have to retroactively work with the Conservation Commission and go back to all these other
No, I
docks
mean,
and
you
treat
have
them?
many that are going to be grandfathered or built with proper permits, and
Okay.
I wouldn't worry about. I think there's a thing, and I see Mr. Fitzgerald here from, used to be the building inspector in Norwell. I mean, you walk in, what's done by past practice is something that I think you really can't focus on.
Correct.
Okay? I think what you do is you go forward, you interpret the bylaw. If you get a question, you ask me, and I either agree with you or I don't. I try to give you the best guidance I can.
Right.
I don't think you need to go back and start looking at everybody that didn't do the right thing, because
I agree.
we would never see you again.
I
'cause you would
agree.
be-
And that's why I wait until these requests for
Wait,
enforcement.
You wouldn't make it down Spring Street,
I know.
okay? And 20 years later, you'd get to Summer Street,
Yeah.
okay? And then you'd get to Green Harbor and Brant Rock and all of the other places where we have
Yep.
docks. So
Thank
I
you.
don't think you need to go back and fix everything that's ever been done wrong. In terms of permitting going forward, because this wasn't properly permitted before, you have to kind of treat it like it didn't exist. So I do think regrettably, a special permit is probably needed for the Inlands Wetland District issue. It's a permittable project, it's not a prohibited project. This board has allowed significantly more than what would exist on this site in many other locations in the Inland Wetlands District. If you get down to Island Street or some other areas, there's even a coastal wetlands district issue. We've granted special permits that allow far worse than what this is. But again, it has to be applied for, and then you could get a building permit after the fact for it, to the extent that it's different from what the board originally approved for the dock. I think on the night that they come in for an inland wetlands permit, you should deal with this as a minor modification. And then, as far as I'm concerned, and Andrew and I may disagree with this, but my opinion is Concom issues are Concom issues. Wetlands bylaws, State Wetlands Protection Act issues have to be the Conservation Commission. Certainly understand what Andrew's talking about, because as the floodplain administrator, there is some language in the bylaw that talks about him, making sure that all of the permits and approvals are required. And I think he can draw that to somebody's attention, but he can't enforce it. And I told him that privately before. I think any matters that are conservation issues have to be referred to the commission, and the commission will handle it in whatever wisdom they see fit.
So your opinion is we don't have to address that issue at all?
I don't think you should address it, candidly. I think it should be referred over to the commission, and they should handle it in the most appropriate way. And I've learned a little bit about this particular circumstance, and I've learned a lot about some other practices that are ongoing on the river, and I told that maybe docks are stored above the seasonal high tide line, and that's where they have been, and I heard that's one of the circumstances that are occurring here. That's a Concom issue. It's not our issue. So I think you should stay clear of all of that. So summarizing it from my perspective, these permits did not lapse. They're still valid. They were substantially exercised. And I disagree with Andrew over this issue. In terms of what you have on the ground today and what was there before, I think that could be addressed on the night that the applicant comes back in and asks for permission to construct this structure legally in the Inland Wetlands District. And I said what I said because it's true. We allow a lot worse than this by special permit. And I think if we add up the square footage of probably these 4x4 posts, if that's what they are, or 8x8 posts, we're talking about a grand total square footage of about, two cubic feet
Not a lot.
or 2 feet or something like that. So it's not a large area there. And then I do think once they've obtained that permit, it should be a requirement that they get a building permit. If you don't get the inland wetlands permit, you can't have it at all, and it'll have to come down. So, but again, I've given you the benefit of my experience and my judgment here, and I think that's the right answer.
So as to the
Can I-
the four issues, number one is moot, number four is not before us. It's only 2 and 3 that we need to approve or disapprove of Andrew's violation.
Yeah, so,
I want to point out what the actual order is, because actually it doesn't disagree at all with what Bob has just said or why Attorney Brodsky is here. Reestablish your rights to the variance and special permit for the Zoning Board of Appeals for case 1424. We've just done that. Attorney Galvin has just confirmed that he has exercised those rights, so the ZBA has now confirmed and reestablished those rights. So that's been done. Record the decision at the Plymouth County Registry of Deeds. They did that. Submit an as-built to the ZBA. They complied with that order. obtain Conservation Commission, ZBA, and Building Department permits after the fact for the construction of the gazebo structure. That's what Attorney Galvin is suggesting. Or they'd have to remove it, which is what would have to happen. Then they have to obtain Conservation Commission approval for all the development and disturbance activities related to the use of the tarp, which is a development activity. Comply with any relevant enforcement orders from the Marshfield Conservation Commission. I'm just asking them to comply with the Marshfield Conservation Commission. I'm not enforcing anything. I'm not creating any violations or fining them or anything for anything that they've done as far as that. Just asking them to go to the Conservation Commission and do whatever the Conservation Commission feels is required. So I don't feel like any of the things that have been requested in this notice of violation are actually anything that they aren't here for anyway, or are requesting the board to do anyway, which is to consider these violations and act on them, which is what we're doing here tonight.
So I'm going to respectfully disagree. We're not here, and we're not seeking to reestablish our rights under the special permit and the variance, because I agree with town council that
Well, he did just point out that he was requesting that. He was requesting guidance from Mr. Galvin as to whether they lapsed or not.
Yes, sir. I'm just saying that we.
So it's pretty much off the table. He's all set.
Yeah, we don't.
Yes, sir. I disagree with it was necessary to appeal this notice of violation for several reasons. One, if Mr. Kilcoyne did not comply with it or file an appeal, and it's right in the notice, he is subject to fines. So it is effectively an enforcement order. It's not a friendly letter. Dear Jim, I've got some concerns regarding your Ramada. Why don't you come and see
He
me?
wants to be treated like everybody else. Nobody gets a friendly letter. Nobody likes getting that.
Oh,
You know,
nobody gets a
so-
again, under past practice, people would get a
If we can move
phone
this-
call.
If we can move this along.
Yes, sir.
What I think we got here is Mr. Galvin pointed out,
Just two issues.
yeah, there's a couple, apply for a building permit.
Yes, sir.
At the same time, whether the expansion of the seating area was a minor modification, which would be up to the board to make that decision, I guess, and whatever special permits are required. But he's not the first person to be in front of this board, in front of the town for not, pulling a building permit. Whether it was an overlap, clearly he spent a lot of time, energy, and money getting this project permitted. So was it an oversight? Very likely. Is it something that we can't get past? I don't think so. I think Andrew's done a very good job, pointing all this out. Again, that letter, it's not fun to get. I wouldn't want to get it, but I think this is something that we can clear up with what Mr. Galvin's pointed out. I think we can move along with this.
No,
So do
sir.
we have any other stuff from the board? Any other questions from the board? Anything from the audience? Does anyone wish to speak on this?
I'm not sure that I don't have a conflict of interest. I worked for 20 years with Mr. Galvin, 18 years, and I'm currently working for Adam Brodsky's law firm as a consultant. So I don't know if I say anything, if it's conflict of interest.
I don't think you have a conflict of interest.
Do you want to just identify yourself for the record?
My name is Tim Fitzgerald. I live at 84 Booth Hill Road in Situate, Mass. I served on a conservation commission with Adam Brodsky in Situate for 3 years, I believe. And I teach the Rivers Act, I teach the building code, I teach building inspectors, I teach contractors, real estate agents, and I have for 25 years. And there are a lot of inaccuracies in some of the things I've heard tonight, but I don't have the time and I'm not getting paid to say them. But I am going to say that I am building a very similar structure up the road a piece in the next month or so, and it's good to hear that I don't have to comply with everything that the law says I do. If it's good for one person, it's good for others. So I just thought I'd put that 2 cents in. Thank you.
Anyone else in the audience wish to speak?
I'd like to talk.
Okay, could you unmute yourself and identify yourself?
Can you hear me?
Yes.
We can hear you.
Yeah, it's John Cusick from Wyman Ave. I filed this violation on November 5th. Just so the record is for this attorney, for Mr. Kilcoyne, understands that Mr. Kilcoyne responded to the violations I sent to conservation, and I also sent it to the building department on November 5th. And Mr. Kilcoyne responded on November 15th with a letter to the town administrator, to conservation, Mr. Grafton, I believe Mr. Galvin. I got this information as a public information request, which I do file quite a few of them. So to have this attorney, I'm sorry, I think his name, is your name Mr. Brodsky? What's this attorney's name?
Yes, Mr. Cusick.
Yeah, okay. You know, to have you come before this board and say that your client needs some type of special notification, when he was notified on November 5th, he understood the exact violation that we're talking about tonight on November 5th, and he responded to it. And in his response, one of his responses were that he wasn't a member of conservation when the violations occurred, which in fact, I'll call it like it is, that was a lie. He was a member of conservation. I actually have the letter that he accepted, and it was in February 2016. And these violations happened after that. So, I just don't want to listen to Mr. Kilcoyne's attorney try to say that Mr. Kilcoyne was never notified and he needs special notice. The second thing I'd like to address is that in your response, Mr. Brodsky, you did mention something about well, if he needs a permit or all of this, every individual that's in violation needs to be reported. And so I would suggest Mr. Kilcoyne could do that, but when you do that, you have to fill out the form, the complaint form in detail, and you have to sign it, and you actually have to deliver it in person at the either conservation, if it's a conservation violation, or at the building department. So I suggest to Mr. Kilcoyne, if he wants to do that, he can run around town and see different violations and fill out the form and do it himself.
All right, John, we have to stay on point with our stuff today.
I know, but it's the certain things. As I agree with the shed is a structure, it's over 64 square feet. I know there's other violations. The top, using it as a test to see if he could kill wetland plants.
That's not in
front. I know that's conservation,
So we're gonna stay on we're just sticking to the stuff that is the zoning information that we're dealing with tonight.
Well, just so the board knows, through the chairperson here, see, on my screen, it doesn't show that the video of your
No, it doesn't.
It's very small, so I think that's Mr. Murphy.
It is.
So just so your board is aware that Mr. Kilcoyne was informed November 5th, and he responded November 15th to 3, possibly 4 town officials. He responded to the complaint. So for this attorney to come in here and say that he needs, that he was never notified is not true.
Excuse me, Mr. Cusick. Excuse me, Mr. Cusick. We haven't.
We're going to move on to the next, to the next comment.
We're going to move on from here because we've addressed all of this and we have a complete packet. We appreciate.
What's your name? I don't know who you are.
I just said it, Heidi Conway.
Okay, Ms. Conway, I understand and I can tell, but I just wanted to make it clear to the board. I understand.
Thank you, Mr. Cusick.
Thank you.
Thank you, John. Do we have anything else from the audience?
Is there any other members of the audience?
Beth Twinger here from 172 Bay Ave. Can you hear me?
Yes.
Yep.
So, I have no vested interest in this, but I was just disturbed to hear that building inspectors do not enforce permits for docks. Is that like something known in town? Like, it's my understanding that it's highly enforced.
I don't know what you think. You just heard that the building inspector enforces and requires building permits for docks. A prior building inspector may not have done it, but this one does.
Okay. So there's no, like, how do I find the history of that, of which inspectors did not enforce?
Well, the immediate prior inspector didn't always require a building permit for docks. His name was Jim Fokar. He's been retired now.
Yeah, so Jim did.
Oh, we did?
Yeah,
Okay.
Jim required permits for docks, but we had some significant turnover in the years prior to that, and I think there were some lapses in those years.
So I don't think that there should be the generalization that they have not enforced, because historically they have. And so maybe the prior one didn't, but I just want on the record that whoever made that comment, I disagree with. And I think people should be concerned with it.
Thank you.
Thank you.
Anyone else's comments? Well, Bill Grafton popped in before our meeting, and he had mentioned that you're going before Conservation, and I had talked to him about leaving the record open to get that answer. Do we see that as agreeable to the board, or?
I would have no problem with that.
Sure.
All right.
The only problem is if you don't close the record and make a decision, then they don't have to do anything until you've decided this. And if you want them to resolve it, you have to issue an order.
Going back to where we were, Bob, there's just the two issues that are still in play.
I think there are three, but the issues are, I think Mr. Kilcoyne has to come back to the board to make sure that what he's built is okay and consistent with the original permits. I think he needs a permit, special permit for the inland wetlands structure, which is the pavilion. And then I think he needs a building permit. So, and he's got to do whatever conservation requires him to do in connection with any other conservation-related issues.
So if we vote now, we're voting on those three points.
Correct.
I'm
But I
prepared
mean,
to vote if that's the
if you
case.
leave the record open, then Mr. Kilcoyne doesn't have to do anything until you make a determination on his appeal. And I'm not sure, if you want to have the benefit of whatever conservation does, you're certainly welcome to do it. I think it's up to you guys to do that. But if you want them to solve the zoning issues, I mean, the Wetlands Protection Act actually has a policy, and Mr. Brodsky probably knows it better than me, that requires you to actually get all your other permits before you go to the Conservation Commission. So, as far as I'm concerned, my recommendation is, decide this appeal and then make them go get whatever they need to get from the Conservation Commission afterwards.
So you're saying we should close it?
I think you should.
All right.
Mr. Chair, can I just ask for just guidance? I think I understand what town council is asking for. You're asking us to seek to modify the existing special permit for the additional square portion of the walkway,
Correct.
and then a new special permit for the Ramada.
For the inland wetland district aspect of the Ramada structure.
Understood.
And
then upon grant of
assuming you
that,
were to be granted that, then you would obtain a building permit after the fact for the
Ramada. Thank you.
So you, okay,
What,
I certainly understand what town
alteration.
council has
So the
recommended.
seating area where he has the chairs would just be a minor modification.
Yes, sir.
Yes, it is.
Understood. Thank you.
Can I make a comment?
that was my.
I think we're closed.
No, no, we're closed right now.
we're not closed yet.
We are closed, right? Did you vote to close?
We didn't close it.
Oh, you
Mr.
haven't.
Galvin should recuse himself. He works for the selectmen.
All right.
Yeah, I
thank you,
also
John.
work for the Board of Public Works, of which you're a member,
Andrew.
and my job is to interpret the bylaw, which is exactly what I'm doing tonight.
All right, so, I'm gonna make a motion
They appoint
that we
you the
close the, hearing.
I'm sorry?
I'm gonna make a motion that we close the hearing on the appeal.
Second.
All those in favor?
Aye, Chris Belazos.
Larry Keane, aye.
Heidi Conway, aye.
Brian Murphy, aye. Do we want to deliberate, or should we continue and we can do this in the end of the night?
I'm
We
ready.
have a lot of people here. Are we ready to vote?
Yeah, I'm ready
I'm
to
ready.
vote.
All right.
Pretty clear what we need to do, don't you think?
Yeah, I think
So-
it's clear what you need to do.
I'll make a motion that we,
So can I make a suggestion? You want to I think what you want to do is affirm in part and deny in part, okay? What I think you should do is deny the fact that he has to reestablish something, because I don't think he ever lost it.
Why don't-
He may not have complied with all of his obligations.
Why don't we make it simple and just affirm the three things you said and deny everything else without further comment? Does that make sense?
Yep, that's fine. Perfect.
All right.
Shortcut is always the best way.
Yep.
So we're gonna.
Most welcome.
I'm gonna make a motion that we affirm, Bob.
You're going to affirm the fact that the building commission was right, that there has to be a modification of the existing special permit and variance. Okay? There has to be a application for a special permit in the inlands wetlands district. And depending on the results of that, they need a building permit for the structure. And then,
We're gonna deny.
and then you would deny the, any potential finding that there was a lapse of the original special permit of variance.
Everyone understand that?
Yep.
I need a second.
Second.
All those in favor?
Aye, as stated by Attorney Galvin.
Very keen, right?
Heidi Conway, aye.
Brian Murphy, aye.
Thank you very much.
Thank you.
Good night.
Lynn's up there. Is Lynn's up there outside, or?
No.
There. We should leave it open.
Yep. Take a short recess. Take a 2-second.
Yeah, I'm gonna take a
Motion to
2-minute recess.
Yep. Second. All those in favor of taking
Aye.
a 3-minute recess?
Aye.
Aye.
Right?
Aye.
All right,
We're taking a recess for 2 minutes.
couple minutes. Stretch.
What's next on the agenda, right? That's good. I thought I was next, and I'm like 3 away. Oh, what a bummer.
We can move you down. The death job.
Yeah.
Someone's gonna do that.
I know, right? Yeah, move me up.
You probably need to.
Rollers and Reese's.
Oh, I need a Reese's.
You gotta pay for seeing it.
Still in the back.
I don't want to leave.
Like the church.
Lingering. I don't believe there is. That's why I wanted time to deliberate.
Jeff, what are you here on? Which one are you?
That'd be considered a bribe.
E, it's just a small.
Tedeschi?
Yeah. No.
That's not
Is
good.
that why you're here?
Yeah.
He didn't give us any deliberation time.
Your friends from Ralph and Catherine?
I live 2 houses over. Where do you live?
On their council. Just cash tonight.
I'm more concerned with the house next door.
Which side? On the other side.
Right.
They're, what are they up to? What are they up to?
Oh, they're, this is great. I'm just gonna notify the building inspector.
Okay.
That is.
Bill has.
Bill
permitted
does,
it.
Bill does. Because I'm.
Oh, so they didn't get a building.
But it sat for like 7 or 8
That
years.
wouldn't work tonight. But
And
that wouldn't work really either.
phenomenal.
I might need to get somebody else.
But in the end, the judge is like, sorry, you're out because you waited too long, and the town can infer abandonment for 7 years and you're not doing anything.
But it's-
That's good.
So we're done with this one? I can throw this
Yeah,
out?
Chris just is asking, we really didn't get a chance to deliberate. He's just asking another question.
You're closed?
No, we decided it. He's just
Oh, you
asking.
voted it?
Yeah,
Oh, okay.
Yeah, it's done.
Okay.
we did the usual. I just had Bob say whatever.
I'm on, right.
Articulate.
I would think. No.
Was gonna bumble around.
I'm already on the planner, sorry.
All right. We need to wait. Or we can sit over there. No, we're missing.
Feeney's out there stretching his legs.
Your friend.
It's over.
We're missing a couple folks.
I guess what they're
Things are
choosing
out
to
of
do is a
control.
little bit more conducive to.
Yeah, that went,
Like, it's not their-
that went better than I was hoping.
Guys.
What?
Yeah, it's very different.
That's a tough spot to be put in.
I agree.
Lost two, but. I'll show you. 30? Did you get a lot?
I have my charger's there. Oh, no, it's not.
Fairly smooth sailing going forward.
You hope. I'm getting like 10 a day. This is my thing.
Sorry.
Yeah.
That's all right.
I was so focused on my own crap.
You did a good job.
That plastic up there.
It's
Just let the light in.
Question was though, if going off the other way and stuff like that, and my question was, what if it's a condition, the zoning condition? Like, can't store the.
A rendering for Preston Terrace.
Right.
Is that the next one?
Which one's next?
I didn't send anything out on this, I just realized. It looks fine, but it's like,
We ready to get started, guys?
Yes.
Okay.
from what I remember.
Everybody good?
Yep.
That's the chair, not me, by the way.
All right, let's bring this meeting back to order. We had a short recess, and Brian Murphy was the hearing officer for the previous hearing, and I will resume my responsibilities here, and we will, I believe we have 10 more to do. God, really? Yes. Sorry.
Expeditious.
All right, to, yay, so everybody, we'll get through it. Do we have case 2233, William T. Ryder for 3 Preston Terrace here this evening? Good evening. Welcome, have a seat. I'm going to read this into the record. Before we get started, I'd like to make a motion to come back from recess. Do I have a second?
Second.
All those in favor?
Chris Bellows, aye.
Larry Keane, aye.
Glenn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Alrighty. So this is case 2233, William T. Ryder. The petitioner is seeking a variance in accordance with 305-10.11 of the Marshfield Municipal Code for relief from 305-11.09C.6 and a special permit in accordance with 305-11.09 to create an accessory apartment in the previously approved 24-foot by 29-foot attached garage that will soon be constructed on the property located at 3 Preston Terrace. which is further identified on the assessor's maps as being on parcel I-1604-01 and is located in an R3 zoning district. This particular property has been in front of us before. It was a case 15-34, case 18-82, and previously came in front of us for an extension to February 27th, 2023. So welcome to the ZBA, and if you'd like to explain your project to us, we're all ears.
Well, it goes back a little bit there.
Yeah, it does. It does.
It burned down, the
Yeah.
garage, the existing garage, and I had another one. I had some designs done by Rockwood Design, and I had a contractor brought in, and I gave him too much money, and he bailed.
Okay, I'm sorry to hear that.
And I reapplied for a permit, and I got a permit under my own name, and I had Andrew brought up to the house, and he identified some flaws and different things that would have to be addressed before it go any further and all of that. So this is pretty much where I am.
Okay. So you're in front of us tonight for an accessory apartment in that attached garage.
Yes, that was included in the design when I got it
Okay.
from Rockwood.
Okay. And
All
I
that.
don't recall what the board had to say about that, but,
It was at the time we had the 3-year statute,
3 years,
so that
so
was
it-
pretty much it, is they were
Okay.
creating the addition, then they were gonna wait
Wait the
3 years
3 years.
before creating the accessory apartment.
okay, I'm with you. Okay,
So we're 3 years.
all right.
And now we are all well aware that
Yeah.
we're axing that requirement.
So for this, the existing special permit is going to go to February 27th, 2023. But let's take a look at the plans that you have. The deed, everything remains the same. It's still under the same ownership, correct? Yeah. Yes.
Yeah, I've been there 45 years.
Okay, you never know. Sometimes some child or something, you never know. I have to just ask. Okay. So, is there any change other than, originally,
That's it.
the design of your, garage?
Nope,
Now
that's
you
it.
have the same window, okay, everything's the same.
The space is essentially the same, the layout is exactly the same, it's just that in this dining area, they'll be able to put an actual kitchenette
Okay.
type area with cooking facilities.
Okay.
But nothing's gonna change as far as the sitting area, the 1 bedroom, the bathroom, none of that is gonna change.
Okay.
But it has all the necessary things for a dwelling unit: laundry, bathroom, sanitary, cooking, sleeping.
Okay. So this had a septic, Board of Health reached out to us. So you had a 3-bedroom septic field, is that correct?
I had a new septic system installed in 2000, and
Okay,
Jay Gary did it.
okay, all right. So you have enough bedrooms to accommodate this accessory apartment in your septic field?
That's correct.
Okay, all right. Any other questions from the board?
No, thank you.
All right.
Bill, was there a permit to modify the existing building to eliminate a bedroom, so it would be 2 in there and 1 in the other house? Is that, or was it always
Yeah,
just?
it was gonna be 2 and 1.
Correct, yeah.
Would be the 3 altogether.
Okay, so are you aware of the reason for the variance that you're here in front of us this evening for the 3-year? You understand that whole procedure, and how that came to be with the town meeting in the fall, and we're waiting for the Attorney General to.
Yeah, there's
okay.
all kinds of stuff
All right,
up-
I'm not
up the
gonna waste
city.
my breath on that,
Okay.
as long as you, okay. So, the actual accessory rules that need to be applied for the accessory apartment Only one accessory apartment shall be allowed per single-family dwelling. The accessory apartment shall occupy no more than 40% of the total living area, and it's obvious that meets that criteria. The accessory apartment shall be designated so that the appearance of the building remains that of a one-family residence, and we already saw this before, so I'm comfortable with that architectural rendering. The compliance with the Board of Health policies and regulations, and the Board of Health has informed us that there was a 3-bedroom, and I'll take your testimony on that. Approved water conservation devices shall be required for the new installation. Almost done. Dwelling must be in existence and not substantially altered for a period of 3 years prior to the filing of the application. And that's the reason why you're here tonight for number 6. So that's the request for the variance, where we're waiting for the Attorney General to respond for our, to accept our town meeting from the fall. And this is a R3, so you are 10,000 square feet, and the square footage is correct, right? Okay, and the parking is going to remain, you have enough, where's the parking space for this?
It's going to remain outside.
Outside the garage?
You've got the garage, and they have spaces outside the garage.
Excellent. And the principal dwelling shall be occupied by the applicant owner yourself as your principal residence, and you need to comply with the state building code. And then Andrew will send you a reminder in January, correct?
Yes, prior to
re-up?
January, to re-up in
Yeah,
January. Yep.
so you need to stay in touch with the, yeah.
Current.
Yeah, it's like a dog license, yeah, you just have to keep coming back every year, so they can keep you on track, okay? All right, so I'd like to, planning board did not weigh in on this, correct?
They had no comments on this.
Okay, all right, so.
So how do we need the variance for this, Andrew, even though it's been
Still.
3 years?
Been 3 years, you still need it?
He hasn't done it yet.
He's
Hasn't
about to
completed
do it.
construction yet.
Oh,
He
okay.
hasn't done it.
Like I said, his initial permit, he had a contractor that, quite frankly, really did him wrong. Second one tonight, where we've had somebody who's in this
Yeah.
position because of their contractor. So I've been trying to help Mr. Ryder through that situation, so he had to reapply for a new permit under his name. So he's still actively constructing the space. Yep.
Okay, so, and then if you go to transfer the ownership, if you sell it to somebody else, there's regulation for that as well. So it shall terminate upon the sale of the property to a new owner, and then that new owner has to come back and apply for the accessory unit.
Right.
Okay? Any further comments from the board?
I don't know.
Any comments from the public? If you're dialing in, you need to press *6 to be heard. All right. All right, I'd like to make a motion to close case 2233 for 3 Preston Terrace. Do I have a second?
Second.
Seconded by Heidi Conway. All those in favor of closing?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Okay. So we are now closed. I would like to make a motion to grant the variance, acknowledging that the town is waiting for the Attorney General to accept our town meeting. Do I have a second?
Second.
All those in favor of granting the variance?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
All right. So that is all set. I'd like to make a motion to grant the special permit in accordance with 305-11.09 to create an accessory apartment. Do I have a second?
Second.
Second by Heidi Conway. All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
All right. So you are all set. So this, so you have the existing going to February 27th of 2023 for the other special permit. So this will give you 2 years on the decision date. when we,
Well,
get
hopefully you can get it going and get
Yeah,
it finished
so-
now.
You got a little work ahead of you, but good luck with your project.
Okay,
All
thank you
right,
very much.
Thank you for sitting with us this evening.
Thanks to the board.
All right,
I'd like to
excellent.
thank Nancy and Andrew
Yeah,
for
have a
their help
nice
too.
evening. Yep.
Thank you.
They were great, I'm sure. Thank you.
Thanks, Bill. Yeah, I'll talk to you tomorrow.
All right, do we have case 2234, case 160 Bay Ave?
It's me.
Hello.
Hi.
2234. Ralph and Kathleen Tedeschi. The petitioners are seeking a special permit in accordance with 305-10.12 of the Marshfield Municipal Code, constructing approximate 8-foot 6-inch by 17-foot expansion of the existing covered deck and a new attached 8-foot 8-inch by 7-foot deck with stairs on the property located at 160 Bay Avenue, which is further identified on the assessor's maps as being on parcel M050703 and is located in an R3 zoning district. So if you'd identify yourself for the record and explain to us what you have planned for this project.
Thank you. My name is Attorney Jeff DeLisi with Ornberger, DeLisi and Harris. I represent Ralph and Kathy Tedeschi. I'm here with Dana Altabello, who is with Merrill Engineering, our engineers. Also part of our team, but not with us tonight, is Julie Johnson, who prepared the architectural drawings for this application. Very simply, the property is located in the R3 waterfront zone, and it's also in the floodplain overlay. The lot is pre-existing and non-conforming with respect to area, frontage, and width. The dwelling on the property is pre-existing non-conforming to both the north and the south side yards at about 3 and 4 feet respectively. Essentially what we're proposing to do, and I don't know, Andrew, if you can go actually to the next one, which would be
Hey, do you want the plans?
yeah, Julie's plan. Very simply, one more.
Yeah, outside.
Yeah, there you go, that's a good one. So you can see on the photograph on the bottom left is the existing back of the house. That's standing with basically with the seawall at the back. And there is a roof overhang that is approximately to the railing. And then there's a deck at grade. And what we're proposing to do is extend that roof about, I think it was
8'2".
8.5 feet into the decking area, and that would be put elevated to be at the same level as the first floor, the existing first floor of the house. And then we're proposing some stairs down to grade, and then there would be a little deck below. We're not increasing, or we're not going any closer to the side yards than we currently are, and we're not going to be violating the rear yard setback at all. And so I think it's a pretty straightforward special permit under section 10.12 and a finding under Mass General Law, Chapter 48, Section 6. Dana's here if you have any questions regarding the engineering, but that's pretty much it.
Andrew, will you just outline the proposed location of the addition for me?
Sure, so this is the addition.
Yeah.
On the existing, portion of the deck here would be the enclosed patio, and then this is the section would be the open deck
Yeah.
with stairs.
Okay. And then you're going to keep the 3.7 on the left and the 3.0 on the right.
Yeah, we're not going closer. Actually, the way
Where is that number?
So they're actually stepping it back, so you've got this 3 feet to the
I didn't see-
existing.
okay, yeah.
And they're gonna step it back from where those stairs are. They're actually gonna step it back so you have more. And then where the deck comes down, it's gonna be 4.1, so you're actually increasing it by a foot and a half there.
Okay,
We're making it better in common parlance.
okay. All right. Any questions or comments from the board? Any questions from the public? This is in a floodplain. Any comment? There were no comments from planning, correct?
No comments from planning now.
So just as far as the elevations, because we're in the floodplain.
Yeah.
The existing grade is about 10.3 feet above sea level. The first floor elevation of the existing dwelling is about 17 feet, and we'll be matching that. So we're going to be conforming with the building code requirements and FEMA requirements on this property.
Okay. So, Andrew, you'll be all over that.
He has to be pursuant to the bylaws.
It's my job.
Yep, that's his job. As built and occupancy permit, Andrew?
Yes.
Anything else? Other than
Are you
that?
still taking, comments from the public?
I haven't asked the public yet, but I will.
Okay.
Yep, thank
Okay,
you.
sorry.
Yep,
Those are the only requirements for building,
okay.
because they're not proposing any elevation changes. We won't require an updated elevation certificate.
Okay. All right, thank you. Anything else from the board? No? That being said, any questions from the public? You're welcome to speak, ma'am.
Oh, that's good on 172 Bay Ave. I do not have any objection to the plan, but I'm concerned with adjacent property, out creeping. I don't know how to, what the terminology is.
Would you say that word again?
Well, encroaching probably is
Oh,
just what you meant.
encroaching?
Yes,
Beth, okay.
similar expansions and to adjacent properties.
So this property is becoming not any more non-conforming than it is, and it's becoming actually a little less on that side. What specifically are you concerned with?
That adjacent properties will, in the future, ask for something similar.
Well, they have that right to ask for something similar.
Yes, so Beth, according to our bylaws, the adjacent properties do have the ability to ask, come in front of this board and fill out the appropriate forms and all of that, and sit in front of the board and ask for relief if necessary. So I can't really assure you that other adjacent properties won't be asking for this, a similar project or something of this nature.
Okay, thank you.
All right, thank you for chiming in, appreciate it. Any other questions or comments from the public? Okay. All right, so I'd like to make a motion to close case 2234 for 160 Bay Avenue. Do I have a second?
Second.
All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
All right, so 2234 is closed. Acknowledging the board has reviewed the requirements as identified 1 through 10 and that this lot is a home and it's pre-existing non-conforming and is also located in the floodplain zone under Article 15. We will also need an as-built and an occupancy permit as our conditions. Is there anything else the board would like to see added to this application and hearing? No? Okay. I'd like to make a motion to grant the special permit in accordance with 305-10.12. Do I have a second?
Second.
All those in favor?
Chris Mellors, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Patty Conway, aye.
Ryan Murphy, aye.
All right. So we are closed.
Thank you very much.
And granted at 5.0.
Yes, thank you very much.
Thank you. Nice evening.
Yep, you
All
too.
right.
Thank you.
Do we have the applicant here for 1230 Forest Street?
When would it be from the electric?
Linda, you were accusing the electric.
At the solar, yeah.
Yeah, the solar she is. It's the one, that book.
1230 Forest Street, Dominique D'Angelo?
No, we have 4 people. She's not feeling it.
Have you heard from them, Nancy?
No. I don't know if they're on Zoom or not. I know the builder or the contractor did the filing.
All right, I'm going to just highlight this and we're going to move on.
This guy's right down the street from my office.
We can revisit it at the very
No
end.
idea.
2236 Patrick Connolly, and this is for Commerce Way, and I am recused. Welcome, gentlemen. Brian Murphy will be your hearing officer.
Excellent. The ill-prepared person will handle this.
We salute you.
All right, so, case 2236, Patrick Conley, the petitioner is seeking site plan approval in accordance with 305-12.02 of the Marshfield Municipal Code to construct a large-scale ground-mounted solar photovoltaic installation on the property located at Commerce Way, which is further identified as assessor's maps as being parcel D09-01-36A and is located in the I-1 zoning district in the planned mixed use district, the PMUD. And what is that what is that word?
Photovoltaic. Yep.
That's what I said.
That's right.
All right.
PV is easier.
Thank you, Mr. Chair. I'm Patrick Conley with Beals Associates, and with these Lucas Faria and Cam Knowles from Galehead Development. So they are the developers of the project, and then I'm the civil engineering and permitting consultant. And so what we're proposing here is a actually, I'll let Lucas and Cam introduce Galehead for a second.
Yep.
And then we'll move quickly through this because we know I don't know if it's time is the essence.
Absolutely. Yeah. Thanks, Patrick. So good evening, everyone. My name is Lucas Faria. I work for Galehead Development, and just wanted to give a brief overview of Galehead and our process, keeping in mind, just the time. But to start off, Galehead is a solar developer based in Boston. We develop both utility scale and distributed generation projects. Utility scale is typically, the hundreds of megawatts, which is comprised of hundreds of acres that you typically see out in the desert, connected to much, probably transmission infrastructure. What I'm working on at Galehead, and I'm currently managing a portfolio for distributed generation, which is anything below 30 acres for either ground-mounted or any other kind of solar project. And Cameron is supporting me in that effort as well. But just to go through real quick for the process for the development cycle of solar, when we first select a project or when we target a certain area, we take 3 main criteria into account. One of them being the land opportunity, the other one, the interconnection, and the third would just be the financials or the returns of the project. The land opportunity, we definitely, do our due diligence to make sure that the zoning is approved. And also we try to get site control as early as possible to make sure that we can move other things along. But also very early on in the project, we'll submit an interconnection application to the utility, this case being Eversource. And that process is typically the riskier part of solar development, and also we don't have as much control of the schedule as we'd like. So to start off, to mitigate the risk, we look at places that have modern and robust utility infrastructure that would be able to take the generation that we're putting onto the grid, as well as in fact, Eversource puts out a public hosting capacity map. That's what they call it, and we use that as an indicative resource for us to make sure that there is in fact space for us to plug in our project in this location. But then further along in the process, the interconnection application can take sometimes between 1 to 2 years, and we try to do our action items in parallel with that. So sort of rounding up this entire process, right now we're at the last stage of this interconnection application, and that's the step is called the transmission study. The only tricky part is it can last anywhere from 3 to 12 months. So we're hoping that within the near future we have some sort of response from the utility. That way we can move forward with the project. But now we're in a good place where we've already received enough feedback that this is in fact a viable project from the financials and anything else related to interconnection. One last thing I'd like to add actually is I mentioned site control. That can be in the form of either, from our practice, a lease option or a purchase option. And in this case, we entered into a purchase option agreement. Since then, it's actually a very recent update, but we are actually now the owners of the property. So we're committed and intend on moving forward with this per the town's approval, of course. Now I'll actually hand it over to Cam just to give a few specifics about the project, as he's currently managing this as well.
Yeah, so just a little bit of background on how we came to the property at Zero Commerce Way. We originally targeted industrial properties. One of them, the reasons being, is that there's energy demand on the same electricity lines that are nearby the project. So when we first identified this property as an industrial property, not only an industrial district, but also with three-phase Eversource electricity lines that actually border the property. We identified that and then engaged with the landowner at the time. This was in early 2021 on a purchase option for the property for 1 year. Having the purchase option then allowed us to go to Eversource with an interconnection application and really get that process started. As Lucas mentioned, that can be the biggest delay of the project. And then once we received some good news from the original study that Eversource undertook, that allowed us to move forward with purchasing the property and move forward with that endeavor, even though we had a transmission study that we are currently undergoing. There just some technical details on the project. It's a 2 megawatt photovoltaic facility. We have not spec'd out the exact panels that we're going to be using here. As I'm sure everyone is aware, there's some supply chain issues going on, but we are committed to using tier 1 solar inverter or solar panels. We are going to be using SunGrow inverters, which is a tier 1 inverter manufacturer, along with battery manufacturer as well. That is something to note for this project, is that there is going to be a battery with no liquid being used or contaminants The unique aspect of this project is we're not only going to be exporting energy to the grid when the sun is shining, but after the sun is down as well with the use of the battery. This also is a community solar project, so those who are on the same utility are able to subscribe to the project, and that's essentially how we're finding off-takers for our power, is through community solar. So this could be commercial energy users or residential energy users as well.
So with that, what you're saying is that the power that you're pushing out of there, that gives more in that area for initial use in that area?
So it's interesting with community solar, and correct me if I'm wrong, but community solar, you're agreeing to purchase the added power that's going onto the grid, but if you subscribe to a project, you're not necessarily using the exact same electrons. Right. Those electrons are going to be flowing on the nearby electricity lines.
Yep, that's correct. And just to expand on that, the utility will allocate, what they call bill credits on your bill to account for the fact that the energy that you're using is technically coming from that solar array, even though it may not be feeding it directly. The intention is that over time enough people will subscribe that there will be, a mass change from, the typical fossil fuels to renewable energy.
What happens if they don't?
It's a good question. But in terms of our array specifically, we are lined up with partners that would seek out to fill in that offtake for our project specifically. In general, anyone is able to subscribe and take in the bill credits from that solar array, but there are vendors who specifically do that service. So we will have 100% allocation community solar for this project.
What's the lifespan of a project like this?
Yep. So, typical lifespan, minimum is 20 years. The reason for that is the SMART program has a 20-year PPA, or power purchase agreement, the equivalent of a PPA. After that, we enter into what's called a merchant market, which is just lower rates than we would get for every kilowatt hour that we produce. And we can model that up to 35 years. So, it typically ranges between 20 to 35. For this project, we'd be looking at, the higher end, 35. One of the main reasons being we're actually, gearing this project to be long-term owners. So we have the ability to, own the project and operate it for longer periods of time. Whereas I believe other developers might choose to do just a 20-year larger PPA instead of, managing it for longer periods.
And what would happen with all this at the end of a 20, 35 year?
Yep. So we actually, it's standard practice that we put in what's called a decommissioning bond for the project. So at the end of the 35 years, this decommissioning bond could be used to completely return the property to how it was before construction started. The other option is actually we could, just replace the equipment with whatever technology comes in 35 years. So we could put much higher efficiency panels, better inverters, maybe even a better battery. But there is the option, it's standard practice to put in a decommissioning bond so that you have the option of
continue an ongoing project.
Yeah.
Manned or unmanned?
Unmanned. So typically, you'll have at least 2 visits a year from a operations and management official who will go there and make sure that everything is operating correctly. But we can monitor all of that remotely. So there's not, any need to have any foot traffic or people coming in and out. It's completely unmanned.
Security with it, like fenced off, or?
Yep, security fences. That's actually in the plans. You can go into detail for that as well. And yeah, anything that anything that can be monitored remotely, we'd be getting alerts, if there's anything that's not going correctly with the project.
Okay.
So this is the existing condition site here. It's about just shy of 8 acres. It's almost completely disturbed. I include some. I think it was as recent as 2005. It was completely forested. Then 2007, it was completely cleared, and then it's slowly been growing back. On the right side here, east side, there is pavement, and there's an access road off of Enterprise Circle, and we're going to keep that. That's going to be the secondary emergency access. However, our main point of access, and if you go to the next slide, is the proposed site plan. We're putting the main entrance on the other side, away from the Madison, the residential community to the east. So off of Enterprise Drive is our proposed access way. It has a paved apron right off of Enterprise Drive, but then the rest of it's gravel. One of our key design goals was to really minimize the disturbance on the site, and just the simplest way to do it from an installation perspective, and also just a way to minimize any potential impacts to the surrounding properties. So coming off Enterprise Drive is the gravel road, and then you have the inverter there directly to the north, and there'll be a series of above-ground poles on the south side of this drive. One part of our application is to request a waiver from, I don't have the number off the top of my head, but there's a requirement for underground utility connections, and Eversource is requesting that it's above ground instead. So that would be one technicality there.
Is that done in poles, or is it done on, how is it done above ground, on poles?
Yes.
Utility poles, yes.
Aren't all the utilities underground in the industrial park already?
No, I believe there's an above-ground pole.
On Enterprise Drive coming down from the north. Yeah, we'll actually, Eversource recommended that the point of interconnection come from the other side of the street, so they're going to string a wire coming into our site. That way we're coming in straight. And those circles there represent, the number of utility poles that we'll be putting in. Those are that's the design that Eversource required, being that it's overhead. Everything else on the site is underground. We'll be actually, putting in conduits in the very early stages of the project that will have all the wires running underground, and they won't be seen, by.
So there'll be some above ground connection, but when it gets to the street, it goes below ground?
It's above ground at Enterprise Drive, crossing Enterprise Drive, connecting to 6 poles to where the hand just was in the corner.
Right.
Yeah.
Then it goes underground to connect to the transformer. And then all the wires from the panels will all be underground to that transformer. So within the site, it'll be underground, but
So-
there will be an above ground element.
Yep, the last overhead pole
Is
is
there
where
a
the
letter or
mouse is.
something that Eversource provided that the board can use to rely upon in granting the variance, the waiver? Do you have a letter that just says, we at Eversource want you to do it above ground?
Yep, we have
Because if you have it,
communication.
it would
Their
be
design
helpful.
requirements or whatever.
Yeah, we
Yep.
could probably provide an email.
An email's fine, just something that the board can rely upon.
Okay.
And then the other rectangle there, that's the proposed battery location. And then the series of alternating black circles are proposed evergreen shrubs to block these big components from Enterprise Drive and from Commerce Way. The entire site will be circled with chain link fence. There's a gate, obviously, at this drive to allow for access, and then at the other side where the existing access is. Otherwise, for safety concerns, we'd rather keep the public out. The only source of lighting will be around the transformer. It'll just be limited security lighting. It could be shielded, so there's no impacts. Yeah, again, stormwater-wise, it's existing drainage paths, and we have a trench surrounding all the new infrastructure to infiltrate water, and then otherwise it's pretty we try to keep it simple.
Yep.
Well, I should say, I'll keep it, there's, was one request from the town planner to do, cross sections. We didn't complete this in time to put it in the slide deck here, but, starting here on the, right side is Enterprise Drive, and then we cut through the site, west-east. And so this side over here is the Madison, the residential community. And generally, what you can see is the solar project is lower in elevation. So this is Endeavor Circle. So this obviously is the property there. And then you have a buffer, and then the residential buildings beyond. And we can provide electronic copies, obviously.
How wide is the buffer between Endeavor Circle and the Madison?
I would say 100 to 150 feet based on the aerial. You know, 1 equals 60. Yeah. So yeah, so we're set back 40 feet from the roads per the zoning front yard setbacks, and then you have the right of way, which is probably 35, 40 feet, and then you have looks like another front setback, so 40, 40, 50, say 140 feet, roughly, or 50 feet.
So we'll get peer review on this.
Okay.
Yep. And does anyone on the board have any questions? Obviously, we're gonna. No, we'll get a scoop of it.
Okay.
What are, in your experience, excuse me, what are the possible negative impacts on the town and the environment as a result of this project? No negative impacts. Are there any?
I would say there's local impacts during construction, right, with the earthwork. But after that, it's a very inert use. They're there. They don't move. If you think about it, they don't really put off much glare because the whole point of a solar panel is to absorb the light. So that's a common misconception. People think of them as just a series of tilted mirrors, which that's not the case. So there's very limited sound, maybe right around that transformer, but again, we put it away from the residential area. There's no odor, there's no light, so it's a negative is maybe you lock up the land for 20 years, but a great thing about this site is it's a buffer between the existing industrial uses and the residential uses, so it kind of provides some safety there.
It's also, as a renewable energy resource that is for PV, that we were saying solar, very low height compared to, for example, a wind turbine that you can see from miles away. This, in contrast, is something that is not, a nuisance to look at unless you're right next to it.
Listen to.
Well, sorry?
Or to listen to.
Exactly. Yeah.
The ESS system for storage of the electrical storage supply. So that is, I imagine that's going to be a pretty large scale system, over like 20 kilowatts per hour. Is that correct? Do you know anything about? Do you have specs on that system yet?
Yeah, we do have the specs on that actually. That was, if I'm not mistaken, submitted as part of the package, which is a drawing called the single line drawings, or the SLD. We, as part of this project actually, because it's a 2 megawatt project, it surpasses the minimum threshold for any what we call the SMART project, which is the part of the SMART program for Massachusetts. So it does require a battery. With that in mind, we sized it appropriately for the 2 megawatt system. And it is included in the single line drawings. We also included spec sheets for the exact manufacturer.
All right, cool, thanks. We probably want the fire chief to just review all that stuff because that's ESS system is governed under the fire safety code.
What about, who would be an outside consultant who would do that?
Who would we hire?
Civil engineer? Or?
We would have an engineering firm give us a proposal, and we'd give that to the applicant with the scope of services for review, and then they'd deposit the money, and then would select the reviewer.
Do we need to put up Greg's comments to see, to review?
I think they received Greg's comments already.
Yeah, I
and
sent
that
you
was
guys
the
the town
purpose
plan
of them
comments,
showing
right?
the cross-section.
That's right. And we're in the process of doing a glare analysis. I think we received that about a week ago or so. But to Patrick's point, the whole purpose of solar panels is to absorb light, so we don't anticipate there being any issues with glare.
Yeah, I can confirm that. Dealing a lot with the airport, one of their concerns is solar panels, but the reason they're concerned about solar panels is the cranes that actually install them. One of the misconceptions is it's the glare that'll distract the pilots, but it's actually they're more concerned about the cranes that are installing them and the cranes getting into the flight path. They're not concerned about a glare.
Is there a operation and maintenance plan and evidence of insurance and things like that? Because when the peer review it, they'll be looking for all of that stuff. Have you already submitted all that?
It's all in that original application.
Actually, we've got page 20 for operations and maintenance. It's blank. It's nothing on there.
Is there the next page? Did like a cover sheet for each?
It's not a lot there.
That's the.
Oh, the table of contents goes further. Is that what we're talking about?
That I think that document right there is the operations and maintenance package from Wood is the panel.
All right.
And on that note, actually, I recall a comment within the bylaw. I think this was something that was mentioned too, about having a installer or a contractor lined up for this project. Going back to the whole interconnection process, that's something that we typically don't have a lot of control over. So being the developer, once it gets closer to us having a final answer from the utility, is when we'll reach out to a contractor, or what we call an EPC, which provides engineering, procurement, and construction services, who will build this project.
Have you met with the fire chief at all?
No, not yet.
No.
Just leave this open for now.
You just get a new hearing date about 30 days out, and we'll get a peer reviewer, and we can communicate to them who the peer review company would be with the proposal and a request for money.
All right.
Sounds good.
All right. Awesome. Well, thank you.
Thanks.
We could just move to continue for third.
So make a motion that we continue.
May 10th is the next one.
May 10th.
Number that I don't know.
May 10th, Brian.
To May 10th. 2236 to May 10th. Do I have a second?
Second.
All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Heidi Conley, aye.
Brian Murphy, aye.
And that was at 6:30, correct?
6:30.
30 on the 10th. Okay.
Thank you.
Sometime after that. Thank you.
Thank you.
Thank you.
Thank you.
Here.
Time in here, I want you. Man, it's nothing in. All right.
We still have a couple days for that. Want to grab Lynn? This is 5:10. Okay, the next one.
I don't know the guy.
Good night, Steve.
You right?
He's out of here.
He's out. You guys don't have to recuse anyone. Right?
Irish Easter basket. Easter.
Why would it have to be an Irish Easter basket?
Because it's
green.
green. Oh, this is my grandson's favorite color.
It's like something left over from Patty's game.
It might be.
Yeah, that's what I was thinking.
This went to the paper store.
The reason I asked for
How are we all holding up?
We're getting there.
Living the dream. Let's go.
Okay. And we are moving forward.
out of my
Suffering.
Next.
2237, which is 26 Little's Lane.
Good evening. Can you hear me?
I can. I'm going to, hi, nice to hear your voice. I'm going to read this into the record, just a sec. Oh, allergies killing me. Okay. This is 2237 Leonard Snyderman. The petitioner is seeking a special permit in accordance with 305-10.12 of the Marshfield Municipal Code to construct an approximately 35-foot by 10-foot addition to the northerly side of the existing dwelling, an approximate 9-foot by 5-foot bathroom addition on the basement level, and a 31-foot by 23-foot carport on the property located at 26 Little's Lane, which is further identified on the assessor's maps as being on parcel D20-01-21 and is located in an R1 zoning district. So let's see what we have here.
Should I go ahead?
Just a sec here.
Okay.
I'm just gonna put up this site plan. Does this applicant also have the deed?
Yes.
Okay. We have Board of Health information on this with Gary. Did that get followed up on today?
I spoke with Andrew. He's the one about you were fine.
I don't have anything from the Board of Health specifically on this.
Okay. He sent us an email at 1 o'clock this afternoon regarding the,
Did you see that? Yeah.
I did, yeah.
There's just nothing in it.
the leaching field being in the right of way of the house.
Right.
Are you aware of that, that there was an issue with the leaching field?
I know at one point, from what I hear, it was in the existing right-of-way, the access right-of-way.
Exactly.
It has been moved back. It's that rectangular box just north of the dwelling.
Okay.
Out of the right-of-way, and meets all, setback.
So have you been in, have you gone through the permitting for the Board of Health?
Yes, as well as conservation.
So I think there's a little bit of a disconnect there.
Okay.
He said it's on hold.
The Board of Health said that their permit is on hold
Yeah,
right
the
now.
Board of Health is telling this board that they are on a hold for your septic.
Okay, I'll have to look into it. I've stepped in for Brendan Sullivan, who's the project manager for that. I was not aware of that. I have the Board of Health plan in front of me.
Okay.
I don't know, are we able to move forward pending?
Can you see her name? Can you see her name? Carolyn.
Let's.
Oh, okay.
How do you want to proceed? You want to just hear? Bob, are we okay without having Board of Health approval to move forward? Yeah, it's not necessary apparently.
Anyways.
Okay.
I mean, if there's any change that required in the plan as a result of some requirement of the Board of Health, they'd have to come back here and
Yep.
modify.
And any building permit as well would require the Board of Health to sign off, and
Yep.
so there's a couple of
Just
checks
like
and balances
the
there.
typical procedure. Okay, so why don't you explain the project? You see this, you see the site plan in front of us. And,
Correct, and I apologize for that, I'm not aware of that. But,
that's okay.
For the record, thank you. For the record, my name is Caroline Reese, PE Cavanero Consulting in Norwell, Massachusetts. I'm representing the applicant, Leonard Snyderman, who is the owner of the lot at 26 Little's Lane. He has proposed some additions to his home, which you read through, 2 residential additions on the north and west side, as well as a carport. There was also a septic rehab upgrade plan submitted that we will look into. And we are here before you tonight because the dwelling has existing nonconformities with respect to, thank you, that side setback is 15.1 instead of 20, and with respect to frontage and lot width, the required is 125 feet and the lot has 102 feet. The proposed work, as you can see in the 3 hatched areas, thank you very much. That's the addition on the west side, in the back. That's on the north side, and the carport are all conforming. So we're here before you because the lot is pre-existing non-conforming. With that, I guess I can return it for questions.
Any questions from the public? From the board? We're looking at the site plan. Just catching up for a minute. Okay. Any questions from the public?
Is there a,
Please identify yourself for the record.
David Armstrong, Little's Lane. Is there a 300-foot buffer from the river to the proposed addition structure?
Not a 300-foot buffer. That may be, 350. There's a 350 for the North River Commission, which is just on sight lines, which are not affected by these additions to the dwelling. Conservation has the 100 and 200-foot buffer. It's been approved by Conservation.
So this has been approved by Conservation already?
Correct.
When was it approved, please?
Oh, goodness. I wish I had that. I do not have that date. It was an RDA. I apologize for that. I can get that too. I don't have the exact date of approval. I apologize. The site plan was a while back. I'm sorry I don't have that date. I don't want to misquote myself and guess.
Okay.
Do you have North River Commission approval on that also?
I believe so, yes, because that was required for conservation. I'll check on that. I'm sorry, Brendan Sullivan is the project manager and is in a separate meeting tonight, but I will check with him. And I believe that was received for, I guess that could be pending for conservation.
Did you have so you don't know anything about the conservation notice of intent?
I know it was approved via an RDA, and I believe back in 2021. I just don't know the date. I could get that to you.
Okay.
Sorry.
That's all right. Do you have any other questions in regards
Is there a
to
height
the
elevation on that proposed carport?
The elevation, there you go. I think it's on towards the last page.
So is that correct that it's lower than the highest point of the existing structure?
Correct.
Andrew, do you have any comments on this project as she's going through?
Not
No?
particularly, no.
Okay.
I mean, my only comment was that the carport's kind of a moot point for zoning because it's technically an accessory structure and it conforms with all requirements for setbacks for an accessory structure.
Completely conforming.
Yes. So I think the real issues that the board has to address are the modifications to the existing structure, which is pre-existing non-conforming.
Yeah.
Is there a change in the, oh, sorry.
No, that's all right. Feel free.
Is there a change in how the driveway access to the house, does it change to enter into the carport?
let's see. No, but I think they're just coming off that driveway. They're keeping the tree. They're gonna try to keep a tree, but they're just gonna kind of drive off with gravel into the under the carport there. They're not changing the configuration of the driveway.
So the carport is open on the three sides, is that correct?
Open, yes.
And is the access point off the facade?
Side access.
Off the driveway, yes. 2 cars would access there. I think it's open on all sides.
See the other thing. Oh, there it is.
That's,
That's
I think,
the other
driveway.
one.
It's right here. I'll show you in just
Thank
a
you,
second.
appreciate it.
I just gotta zoom out.
Bituminous concrete.
I'm sorry.
Here we go, right here.
So it's coming between the tree?
The tree will remain, they'll drive between,
Okay.
I guess, the trunk.
Yeah, that's the lawn, so.
That's the lawn.
Yeah.
So they drove over the lawn.
Well, so they will be modifying the driveway
The
there.
driveway, I apologize. And I actually think that tree
But they won't
is
be,
gonna.
yeah, they won't be changing the location of where the driveway accesses the road, which is really the only concern for the town as
It
far
won't
as
be.
that goes.
They won't be, is that what you said?
They won't be.
They won't be.
And the car,
But as far as this board goes, as far as the impervious surfaces or anything, that's, if it applies, it's to conservation.
so are there 2 bays or 3? I can't tell by this.
Two
The
Two
rendering.
bays.
There are 2 bays. The rendering on the cover sheet just looks different to what I'm seeing there.
It's a different
that's-
look because you're looking at it from a straight on view, and this is a 90-degree structure essentially. That's what you're looking at. So it
Yeah,
kind of
see
looks
how it
like
has
it's
the-
from that view. It looks
Oh.
like it's one big structure,
Looks
but
like
it's
just really
actually
long.
It's just,
carport in front and off to the right, and then the house behind it with the leg of the house
I
coming
think
off.
the post I'm seeing is the post on the rear. They're,
Yeah,
Correct,
it's
yeah, I
post,
think
post.
you're seeing front and back.
yeah, okay. Yep,
That's the front
6
post.
posts.
That's the rear. That's the middle. That's the one in the rear.
That's the
This
rear,
is the front
yeah.
right. That's the rear right.
yep.
So what's the setback of the necessary setback from the edge of the right-of-way to the nearest corner of the carport?
20 feet.
So you have 20 feet of right-of-way and then 20 feet to the nearest corner of the carport?
I'm having a little trouble
so-
hearing, but.
They're required to be 20 feet from the front lot line and 10 feet from any side lot line with an accessory structure.
So does the 10 feet include the 20-foot right-of-way?
No, it's from their lot line.
Okay. So they
But they lot line.
They have full use of the existing right of way.
So, ma'am,
Yes.
are you all set?
Well, I just want to, she asked something about the lot line. So an accessory structure can be 10 feet from any side lot line and 20 feet from any front lot line. This is clearly well beyond any of those setback requirements.
31.8.
Correct.
I couldn't read it from here.
So they have full use right to their lot line. It doesn't matter with the existing right of way.
Quite honestly, the carport should not be a discussion for the ZBA. It's a building permit situation.
Yeah,
Yeah.
it's fully conformed. So pretty much the only reason we're even here is that it's a pre-existing non-conforming.
It's the
15-foot one
15-1,
setback.
which isn't changing.
You're modifying an existing structure that is pre-existing non-conforming.
The 15.1 on the bottom, yep. There is a shed on the front, is that correct? The board would not endorse the shed? Is that?
The existing structure there.
Yeah.
I think that's an accessory, and I think as Andrew said, that's pre-existing, and that is.
It looks,
I think it's
it
a
looks to
deck
be fine. It
something.
looks like it's 20, 10
Yeah,
and 20,
I
yeah.
think it makes a setback.
Okay,
The setbacks are for the dwelling itself that are reflected in the thick dash line.
okay. That's fine. The buffer zone, to answer the question of the public, 100 buffer, okay. Any further questions from the public?
No, thank you.
Ma'am, identify yourself for the record, please.
18 Old Lane. Is that the new septic? I'm concerned about the septic plan because the original plan had a 5-foot swale right at the edge of my property, which I think is a fancy name for ditch, and I was a little worried about it. I'm just wondering, is that the new plan? Because I think the plan was submitted either yesterday or today, and that looks like, unless that drawing was done today, I'm not clear exactly where the septic system goes.
This is dated.
What I thought was the system turns out to be the carport. When I'm looking at this drawing, I can't
Okay.
see it from here.
This, what I'm looking at is dated 3/15/22. Is that accurate for this, what we're seeing?
But I went to the Board of Health yesterday and asked to see the plan, and the one she showed me was not that one. It was the one with the leaching field into the right-of-way.
Yes, so
And
that's
I'm
what
just
we're,
wondering-
Right, the septic has been moved out of the right-of-way, so this is
That's my major concern.
yes, so
correct, yes.
in the
This
beginning,
is
I discussed that.
existing.
So we have a couple of things to do a little bit of work on. So the Board of Health, you need to reach out to the Board of Health and make sure that you're all on the same page and this board is in line with that. We also need the Conservation Commission. I'm just curious as to what happened there. But I think for the purposes of the Zoning Board of Appeals, we are in good shape to move forward. Are there any other questions from the public? No? Okay. Any questions from the board?
I don't have any.
Oh, could I say clarification? So we just provide the data conservation approval. If we have that, apply, submit it to ZBA, would that suffice?
Yes. Did Conservation comment on this project?
He did not.
He did not?
He said he didn't have time.
He didn't have time. Okay. He's very busy. So we will leave that as part of our conditions that Conservation will, if there's been any change to the site or any other conditions that we need to be aware of, so. Anything else?
Nothing from planning,
No.
right?
Nothing from planning, so we only had
No,
the Board of
nothing on this.
Health, and that was it, that commented. All right.
They had
What
time,
did
they
Bob
just
have to
didn't
say?
Bob,
They had
anything?
time, yeah.
Nada.
All right. I'd like to make a motion to close case 2237 for 26 Little's Lane. Do I have a second?
Second.
Second by Heidi. All those in favor of closing?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
So that is the 5 of us. So we are now closed. I'd like to make a motion to grant the special permit in accordance with 305-10.12, acknowledging that the board has reviewed the conditions relative to 10.12, which, as you all have been hearing me say repetitively. They're all set. And the Board of Health will need to be brought up to speed on this, and the applicant will be reaching out to them, and that will be part of the conditions of this decision.
Yeah, they won't get a building permit without Board of Health approval.
But we haven't heard anything other than
Correct.
the letter that says that there's an issue, so I'd like to have that.
And Concom, right?
And Concom, yep, okay. So I'd like to make a motion to grant the special permit with those conditions. Do I have a second?
Second.
Second by Heidi Conway. All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
All right. All right. You're all set.
Thank you very much. I appreciate your patience.
Yeah, please just get back to Nancy with those reports.
Certainly.
Thank you.
Thank you.
Have a nice night.
Good night.
Like wicked loud. Oh, my goodness.
Who's up?
All right. So 2238.
Nap time at the nut house.
But you're gonna be busy.
Hi.
Sorry.
That's you. Come on. Come on down.
Where is it?
Jason Lucetti, the petitioner is seeking a special permit in accordance with 305-11.09 of the Marshfield Municipal Code to create an approximate 850 square foot accessory apartment within the existing dwelling on the property located at 78 Earl George Circle, which is further identified on the assessor's maps as being on parcel D1402-12 and is located in an R1 zoning district. All right. I'll just pull up the application, the site plan. I'll get right to it.
I will send you the North River Drive. Lisa, you promise. Yeah.
So this is going above the garage area that already exists. Single-family home. Do we have a deed? It's
We
not
do.
referenced in the application.
We do.
Book and page. Okay. It meets the criteria for square footage of the lot. Here's the square footage of this lot. You're in an R1. The minimum is 40,000 square feet. What is the square footage of this lot?
I believe it's 41 something.
Okay, so you're okay. Thanks. Feel free to chime right in and tell us what you,
I've lived there for about 3.5 years. Initially, I don't really plan on doing anything with that area. The house was designed and built previous to me. I purchased it the way it was. It's a 5-bedroom septic system, and the 5th bedroom was designed in the existing area that is the accessory apartment. It was designed with an accessory apartment in mind. It has a separate entrance. There's a separate parking area off to the left of the driveway. I think I created a picture of the separate parking area. It has dual access to the laundry area in the house. That's about it. It has a deck off the back that's pre-existing. So everything that's there is pre-existing. Well, the area that it would exist in.
So, the Board of Health sent us a note that this is a septic for 4-bedroom, and you're saying it's a 5-bedroom.
It's a 5-bedroom septic.
They're saying it's a 4-bedroom.
The town has
Does
it.
that surprise you?
Yeah, it does.
Okay.
The town has it assessed as a 5-bedroom house. I don't know why they would have it.
It's assessed as a 5-bed?
Yeah, if you look it up in the assessors, it's a 5-bedroom house.
If it's assessed at a 5-bedroom, but the septic's only at a 4-bedroom with the Board of Health?
I mean, the assessors don't have anything to do over,
Yeah.
It's Board of Health regulations.
So Board of Health would win the day.
Yeah, I wasn't aware of that. So, that's something I have to
Yeah,
revisit
so
with.
I think that, in this case, it might be prudent to have you leave the record open, figure that
Sure.
out, and then come back and see us.
Okay.
But the rest of the project, we're here, we might as well just take a peek and make sure there's nothing we're
Sure, yeah.
missing, okay?
Yeah, I apologize. I mean, when I look at the assessors and it says it's a 5-bedroom house, I automatically assume that my septic would match that.
Yeah.
No, would he have the ability to have an engineer certify the system?
go over the system and see if it would?
Well, if-
Oh, what if you take a closet out in the bed?
It's a little more than that, Brian, but yeah.
I think it would be smart to
Yeah,
chat it over.
if it wasn't, I'd leave the
At
issue.
10:20 tonight.
I'd leave the issue alone, or initially, like I said, I don't really plan on doing anything with it. I have another property if it goes as planned. I was looking at resale value, and if I stayed there, eventually one of my parents would go in there. Obviously, all the plumbing previous to me and electricity was designed for an in-law.
Right.
This is a surprise to me, but
Okay.
no-
Well, you're taking it
no
well.
worries.
We didn't get the email.
I heard a lot of
till late this
interesting stories
afternoon. I
tonight.
know, I'm
And
sure you're overly educated
and
in a
entertained
lot.
for 3 hours.
Oh, I bet.
No
Do you
worries.
need a piece of
Never
chocolate?
get
Just
back.
I feel like I should offer you something.
The chance
So-
to come back.
I know. So how, would you like to proceed?
Yeah, I'd like to dig a
Take
little
it-
deeper into the
Okay,
septic,
excellent.
and if that's the case, then I'll withdraw.
figure it out.
However,
Okay.
it's done.
All right, so you follow up with the Board of Health, and we'll
Can we-
certainly, Nancy,
Can we all, I just want to bring up a couple
Sure.
of things real quick.
Yeah.
So the site plan that we've got here, I just want to point out, this is actually a proposed site plan, right? And, if you look at your house, Jason, your garage is over here now.
It's on the opposite
It's
side.
100% different, right? So.
I got that from.
Yeah, so we have an as-built in the building department in the paper file, but we don't have it in the electrical file, or the digital file.
Yeah.
But if you need the as-built to figure that out, we've got it on file down in the building department.
Okay.
One thing also, just to make you aware, as part of the review, I always look at the properties, and so I can see that you did some pergola work and like a deck or, play structure out back almost, right?
Yep.
So those should have gotten building permits, so you should apply for building permits for
For
those.
pergola?
Yeah, because it's technically an alteration to your house, and it's a framework, so it does require a building permit.
it's a structure, yeah.
So will those
It's
be after the
very
fact?
minor thing, but just because we're permitting stuff happening on the property, we gotta make sure that you get.
Fair enough.
Yep.
All right, are there any comments from the public? We'll just do this one other check. No, okay. I'd like to make a motion to continue case 2238 to a date certain, and let's see where we are.
The new
510, we have 2 cases currently.
the new cases aren't on there because the deadline to file for the May 10th hearing
What does
is
it look
tomorrow.
like?
I think there are about 6 or 7.
Oh my God,
Thank God.
no.
May 24th would be the next one.
All right.
May
So
24th, you said?
May 24th, which might give you enough time to.
I'm in no rush
figure it
now.
out. All right. So I'd like to make a motion to continue case 2238 to May 24th at a time certain of 6:30. Do I have a second? Second. All those in favor?
Chris Miller's aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Right.
All right, thank you.
See you
All
tonight.
right. See you then.
Jason.
Lord, to wait that long for that.
You know what?
You gotta do what you gotta do.
Seriously?
Well, it stinks. Save this one.
We haven't talked to Gary tomorrow.
Okay.
All right, I'll talk to him.
Where's the end of this? So
22,
right?
can someone else do this? My voice is,
You dying?
yeah. 2239.
Case 2239, Sarah Dennis Silver and Deacon Silver.
Thank
The
you.
petitioners are seeking a special permit in accordance with 305-10.12 of the Marshfield Municipal Code to construct a 31-foot 6-inch by 25-foot 2-story addition and a 6-foot by 8-foot 1-story family room extension on the property located at 227 Webster Avenue, which is further identified on the assessor's maps as being parcel M07-01-24 and is located in the R3 zoning district.
Oh my gosh.
Take like a 20-minute recess.
Oh, no.
Everybody
that, wouldn't
needs comic relief. So Brian, do you want me to run it?
I can do it, it's fine.
Go ahead.
Go ahead.
Dick Rockwood, I'm here for the Silvers, for this project. We're adding an addition onto the existing house, which is on the left side of the house. And we're non-conforming on the right side, which is the reason I'm here. But it's a two-story, it's a Cape-style house, and we're adding a little two-story addition onto the house. So, I also have put in to a variance for an in-law suite, but I didn't put it in at the same time. So.
That'll be later.
That'll be later, so, a little glitch in my office as far as getting the paperwork organized. But so we'd like to at least get the approval for the addition.
So does it have the 10,000 square feet?
It does.
Yeah. In-law coverage is all, that's good?
Yep.
Deed, good. What?
Nothing, I'm just talking to my phone.
So any questions from the board?
Board of Health didn't have any, comment on this. Did planning have a comment?
No comment.
No comment at all, okay.
Town sewer.
Yes,
Town
Counselor.
sewer, yep.
Any questions from the audience?
They're all asleep.
Yeah. So we're good?
I would say so.
Yes.
Make a motion to close 2239, Sarah Dennis Silva and Deacon Silva. Do I have a second?
Second.
All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye. Make a motion that we accept 2239, Sarah Dennis Silva and Deacon Silva. On the special permit with the approval of what are those, 1 through 10. We're all in agreement with that.
Yep.
That's it. So Heidi seconded. Do we have all those in favor?
Chris
I have a
Belazos,
question.
aye.
What question?
Are there any conditions?
No.
Just the usual?
Standard. The usual. Okay.
Nothing special.
Good to go?
The usual condition, Dick does this one for free.
Larry Keane, aye.
The as-built and occupancy.
When you come back for the in-law, you'll be
Lynn Fiddler,
last.
aye.
The usual condition
okay.
is
You're right, buddy.
Dick's
Right,
usually
sorry.
the last man
Brian
standing
Murphy,
at
aye.
I've
any
been
He's
first
been
plenty of times.
early.
You've been real good to me sometimes. It's
Yeah,
like, wait a
tonight
minute.
I just,
All right,
Get
thanks,
these
Dick.
two on the last one, and to hear them all three right
Just
in a
one
row.
thing, though, before we,
Yes.
could you just stick around to the end of the meeting? A couple
he
of
wants to
questions.
talk to you.
Don't laugh, because he does
I do
have something
actually-
at the end.
Good.
I do actually have the Anderson,
Well,
the 2 foot.
are you next?
Under other business.
She's been sitting here, do it.
Good God.
It's 20. Was that the first one?
Were you at the beginning?
Continued.
John Lake,
Oh.
Elizabeth and John Lake.
Get out of your way.
Oh, I see.
Okay, here we go.
So, want to go 22, 23, Elizabeth and John Lake. Petitioners are seeking a special permit in, wait a minute, in accordance
What
with
did you say?
305-10.12 of the Marshfield Municipal Code to replace an existing 10.3 by 7.5 foot shed with a 12-foot by 16-foot shed, which will improve the northerly setback and maintain reed setback
Rear.
Rear setback, read, I'm like, what's the read? Rear setback on the property located at 69
There's a
Standish
typo
Street,
in his defense.
which is further late in the night than identified as the assessor's maps of being on parcel K11-09-15 and is located in the R3 zoning district. Go ahead.
My name's Elizabeth Lake. I'm the property owner, seeking a special permit to replace the pre-existing non-conforming shed located on our property. My husband and I purchased the property less than a year ago. We're running into some storage issues, and like many of the homes in the area, we don't have a basement, so enlarging the shed is kind of our best option. The proposed shed, I think you should have received a survey with the proposed shed and the existing shed. But that has more accurate dimensions than what was included.
That's right up there, right? Yep.
Yes. So on the left is the existing shed, the right is the proposed shed, and we'll actually improve the current setbacks. You'll see the proposed shed will bring the setbacks out to 3 feet, whereas the existing setbacks, looks like it's 1 foot and 2.7, I believe, in the current location.
Yeah. Any questions from the board?
Is the shed being pre-built or is it being built on site?
It's coming in pieces, and constructed on site.
Because it looks pretty tight on both sides of your property. I was gonna
Yeah,
say,
the,
if it didn't come in on
a crane,
yeah, you'd have a hard time getting it.
yeah, the company that we're getting it through just required the 3 feet. So that's what we're working with.
All right, do we have any board questions?
No.
So, I want to start, please. So I make a motion to close 22-23. Oh, does the public have any questions? Zoom, nothing.
The only thing I'd say is I did look into like satellite imagery and could confirm that the shed's been there for over 10 years, so it's a pre-existing non-conforming situation.
Okay. So 22-23, Elizabeth and John Lake, 69 Standish Street. Do I have a second to close?
Second.
All those in favor?
Chris Bellows, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Coney, aye.
Brian Murphy, aye. Make a motion that we approve the special permit for 69 Standish Street, Elizabeth and John Lake, case 22-23. Do I have a second?
Second.
Including the 10 requirements. All in favor?
Chris Bellows, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Coney, aye.
Brian Murphy, aye. Thank you.
Closes another chapter in the building department.
It's never going to be big enough. You're going to find a 12 by 16 is not big
You
enough.
have to build a second-story addition.
Doesn't intensify that way?
It's just one big wheel, it's all they get.
So, we still have, you have another one, Dick?
Yeah, and there's the 2 other things.
Here's 2?
No, but we have 2 other things
Durkin's
after.
right? Is Durkin tonight?
Oh, Durkin.
Supposed to be here.
Are you
And-
Durkin? Yep. Okay.
Oh, okay.
Sorry, we skipped you. You gonna do them one, or you want me to?
Go ahead.
Your voice.
Go ahead.
You're on a roll.
You're on
Okay.
a roll.
Yeah.
Okay.
Case 22-29, Anthony Durkin, the petitioner, is seeking a special permit in accordance with 305-10.12 of the Marshfield Municipal Code to construct an 18-foot by 6-foot front dormer and a 9-foot 3 by 10-foot 10 rear dormer and create a half-story on the property located at 75 Marginal Street, which is further identified on the assessor's maps being on parcel M06-03-08 and is located in the R3 zoning district.
Good evening.
Hi.
You ready?
Yeah.
Okay. For the record, Steve Bjorklund, and I'm here with Mike Farwell, who is the builder who is hopefully going to build this addition on the house. And if you remember back at the last meeting, I was somewhat unprepared because I had just come into the mix a couple hours before the meeting. So we put this off, and part of putting it off was to look at a project that was approved by the Zoning Board of Appeals by special permit out on Ocean Street, and how they determined how they calculated, or how you had calculated the 2.5-story requirement in the zoning bylaw. And at that point in time, I was under the assumption that we actually needed a special permit to come in here and build this addition. So what I'd like to try to do, and hopefully everybody can follow along with this, I've done it so many times now that it's really kind of simple for me, but I'm going to hopefully put it in layman's terms that everybody can understand, including, hopefully, my good friend Bob Galvin over there, because he's going to tell you whether I'm wrong or whether I'm right as I say this.
He's wrong.
And I was going to say Bob's a good guy. No, all right. All kidding aside, there's 2 sections in the zoning bylaw in Marshfield that really apply to what we're looking for. And I want to start with the simple one. And the simple one is section 602, Table of Dimensional and Density Regulations. And in that table, I don't know if you have it in front of you, the zoning bylaw or not. I'm going to go through and I'll tell you what it says. You can question me if you want. But there are 8 things listed in the Table of Dimensional and Density Regulations. And I'll say this as they pertain to ours, which is R3 district, which is 1 is lot area, 10,000 square feet. 2 is lot width and frontage, which is 80 feet. 3 is lot depth, which is 100 feet. 4 is minimum yards, which is 15-foot front, 15-foot side, 30-foot rear. 5th is maximum height, 35 feet. 6th is maximum stories, 2.5. 7 is maximum building area at 40%. And 8 is minimum open space at 30%. So that is all the requirements that are listed in the Table of Dimensional and Density Regulations. Okay. I'm going to go over to section 9.02C, which is the extension and alteration of non-conforming structures. Okay. You following along so far, right? I didn't lose you, Bob?
I'm right with you.
Okay. This section 9.02 refers to any non-conforming single or two-family dwelling, which we have a non-conforming single-family dwelling. It says it may be extended or altered or reconstructed, provided the resultant alteration, okay, not the structure itself, but the resultant alteration shall not cause the structure to violate, and there's 2 things, hopefully you're looking right at it. One is the maximum building area, which is 40%. We're at approximately 12%, so we don't violate that. And 2 is the yard area regulation for the district, okay? So when you put that together with the dimensional density regulations, and you go back to the the maximum building area of 40%, we're not violating that, and the minimum yard areas of 15, and 30 rear, we're not violating that with the resultant alteration. The structure itself violates some of the setbacks, but not the resultant alteration. Okay. That being said, the town is allowed to be more lenient than the state when it protects non-conforming dwellings. I think Bob would agree with that. If they had a bylaw that was more lenient than the state, they could do that. Town of Marshfield has done that, okay? You could have put anything in section 902.C that if it were violated would create a new nonconformity, okay? But you only put 2 things in. Town meeting voted and said that our building inspector has the authority to grant an addition for a single or two-family as long as it does not do 2 things, and that's violate the maximum building area or the yard area regulations. He can grant the permit if we don't have the proper lot area, if we don't have the width and frontage, if we don't have the lot depth, if we don't have the maximum height or maximum stories or minimum open space. But he can't grant it for the minimum yard or the maximum building area. We came in here for a special permit, and unfortunately at the time, I hadn't had time to read through this whole thing. It's extremely simple. Your bylaw allows him to grant us a permit. I would recommend that the town might want to change that bylaw in the future, because it is more lenient than what the state says. And you wouldn't want someone to come in and say, I could build a house that's 1,000 feet high. The way I read it, he has the authority to grant that permit. It's not creating new nonconformities, okay? If this were a conforming structure and not protected under section 9.2, you couldn't violate any of those things, okay? You would have to meet all of those, or you would be required to get a variance from any of those. In here, the only thing that we would need to get variances from is if we were violating, if the addition were violating the minimum yard areas or the maximum building area. We're not doing either of them, and what I would ask the board is to direct the building inspector to issue us a permit for the proposed addition.
Is this the dormer case?
I thought we
It
were
was
on
going to be.
75 marginal.
This was going to be in relation to us adding 2 dormers on the house. And the issue, and again, I apologize to Andrew because, again, I was away, just got back last night from New Mexico. I was coming in with the intent that I was going to bring in, which I have with me, my court case that talks about dormers that Bob and I went through at the Supreme Court, and whether we have a right to add the dormer or not. After reading this countless times while I was in New Mexico, heading back from New Mexico, I'm like, we don't need a special permit. This isn't a special permit section in your bylaw. This is an allowed extension under your bylaw as long as we don't violate one of those 2 things. So I think that you should, in the future, change that bylaw if you want it to include any of those other things, like maximum height or maximum stories, or any of the other issues that are on that density table. But right now, for this particular application, I think that the board is compelled to ask the building inspector to issue us the permit, as long as we don't violate those 2 things, and we're not.
No.
Tell me why I'm wrong.
What does it mean by, or by any
Well-
subsequent amendment?
Is this the case where is this the case where whether it's a 3-story house?
Because I thought we were on Durkin, 75
What are we
Marshfield.
on?
It is.
It is Durkin.
Yeah.
It is.
But there should be a new plan in there, because they were supposed to come back with a new plan, which they came yesterday or today.
You brought the new plans in, right?
Yeah, so that should be saved in there. Because there was no PDF, I had to scan.
I thought this was the 3-story structure.
It is.
It is. It's that half-story, not,
Is
not.
it a new plot plan or a new
Not
building?
meeting the
It's not-
2/3
Right-
rule.
right-
Stories is the house now.
Yeah, I
Right
thought you were
now,
talking about that.
okay?
Oh, no,
Well,
no, it was just
It's
the
irrelevant how
amended
many stories it
plan
is right now.
Well, it's relevant to me,
Why
may
is
not
it-
be relevant to you,
Why, well, what's the relevancy?
Can we look at the architectural rendering?
because,
Yeah, she's got them there.
well, I need to see what we're talking about here.
Well, all right.
So that's existing?
This is,
What is existing?
this is the plan you're seeking, correct?
That's the plan that we're seeking. So, and we don't go over the maximum height anyway. I mean, this particular one, we're way under. The peak of the roof is 30.8 feet. So we're under that. So the issue when we first filed the application was, can you allow something to be more than 2.5 stories? And it was a square footage issue that we were looking at. And we have plans we actually have 2 plans. I said I was going to come back with one that was going to show we were going to use the whole attic space, and one where we calculated the same as Ocean Street under the permit that you had issued for Ocean Street. And so there are still 2 plans that are in there. But again, after reading the bylaw again, I'm curious what the disagreement is, Bob.
Well, I'm trying to figure out what exists today. A 2-story structure?
Right now, it's 2 stories and there's 426.94 feet existing on the 3rd level, which is now
The
basically
existing
attic.
is this gable roofs, right? Is that what's
Yes.
existing?
Yep.
And it's just attic space?
Yep.
Yes.
But there's 426.94 feet that are above the 4-foot height.
Does this violate the height requirement as it exists today,
No.
Andrew?
No.
It's conforming.
is conforming to
But
the
then
height
you, but
requirement.
it's your
and
determination
it's
that's be.
conforming to the story requirement.
Okay, but your opinion is this would be 3 full stories, which would violate. Is that your opinion? Yeah, I agree with you.
Okay, so section 902, again, and I totally agree with you if this was a conforming structure. Okay? If it's a conforming structure, it's a whole different section of the bylaw that we go to, okay? And that's where you hit that full table of dimensional density requirements. But I guess, Bob, you'd have to explain to me why 902 specifically talks only about 2 of those requirements, maximum building area and yard area regulations. So what would prevent the building inspector from allowing us any of the other 6 items that are in dimensional density regulations? Why would that cause the need for a variance if section 902 doesn't require it for a non-conforming building?
Because you have because your building is conforming
No,
right now.
no, it's not. No, we don't meet the setbacks. We have a non-conforming building.
As to height.
Doesn't matter. We don't have a non-conforming building?
It's a new nonconformity. You'd need a variance.
No, it's not. Not under 902 in your bylaw. Okay? It's more lenient than the state. Okay?
You have to look at what is non-conforming about your structure before you can just because you violate the side setback requirements doesn't mean you can do anything else you want.
It says we can do any of those 6 things on there. He has the ability to give us the permit.
I don't think that's the proper
Otherwise,
interpretation of the bylaw.
I don't think it's appropriate either, but it's
how do
what
you
the
explain
bylaw says.
How do you explain the last sentence?
The last what?
The last sentence. Non-conforming structures may be altered or relocated in the same lot if it makes the altered or relocated structure more conforming.
That would mean that if I was 5 feet from the setback right now and I wanted to reconstruct 7 feet from the setback, I'm more conforming.
I understand what that means, but you're not making it more conforming.
No, we don't
That's
have
the
to.
brunt of your argument.
No, that's another thing that you...
I understand that, but if you read those 2 sentences together...
They're 2 separate issues.
Steve's one of my favorites, so don't take it the wrong way.
No, I'm not.
I mean,
I'm not.
Steve is a very principled guy, and we've gone all the way.
The difference between Bob and I...
You have to
Wait,
read both of them
you guys got
together.
to understand this. The difference between Bob and I is I'm a layman and I read what's on the page, okay? I read everything that's on the page.
But you're not reading the second sentence.
I don't need to read the second sentence because
Sure
I'm
you do.
not taking the house down and relocating it, okay?
You're altering it.
You need
What
to
it
read
says.
C, okay?
I'm reading C.
Okay. In
It says
C, we're allowed to
it
do an
says-
alteration.
No, my turn. It says non-conforming structures may be altered. That's what you're doing, altering. Or relocated in the same lot. All right, if such alteration makes it more conforming. So you read those 2 sentences together, you can't read them you can't read them in a vacuum.
One is to take a structure and move the structure to make it more conforming.
No, it says alter, not move, alter.
I get that. And,
You're
and-
altering.
and I'm altering it, and you can do additions that are more conforming on a building. Okay, you can do that.
I agree.
And Andrew can grant permits for that. I think he does now, if it's on the conforming side of the house.
No, I don't. We always go into the ZBA for those.
If they're, I don't think you have to.
So how
I mean, based on what this says, you only need to come to the ZBA if you violate one of those 2 things.
In theory, I agree with you, but in practice, that's not the way we've operated.
This is my point, okay? I don't believe that Marshfield has done it this way, and I was prepared to come for a special permit, but when I read it, we don't need a special permit. I mean, we'd accept one if they agree that we can make this alteration that we want to make, but I don't think the bylaw requires us to do it. It is very strange that you're more lenient than the state. But if you can find the words in there that say that he doesn't have the authority to do it, show me the page. I don't think it's there, Bob.
I think it is. I think it's a conforming structure as to height. And I don't think because you have one dimensional requirement that's non-conforming, then you can just do anything you want that's also non-conforming, even if it's a new non-conformity.
You can only do...
That's an illogical...
You can only do 6 of the 8 items that are on here, okay? 6 of the 8 are on dimensional requirements, okay?
I mean, I'm happy to,
Oh, you're gonna need to look into it, for sure.
No, we're happy to, I'm gonna give my opinion, you've given yours, and,
Okay.
I mean,
So-
I don't think you're allowed to make Just because you're one non-conformity doesn't mean you have to comply with anything other than the building area and yard regulations? You think that's the only thing you have to do?
That's exactly what your bylaw says.
So.
It's unfortunate, but it's exactly what the bylaw says.
So you think you could go 4 stories?
You could go
5
1,000
stories?
feet, I think I mentioned. It's the wrong thing to have in the bylaw, but it's what's in your bylaw. You can't add words and you can't take words out. That's exactly what it says.
So when you look at the bylaw as a consistent whole, in my opinion, this does not mean that you can then create a new nonconformity. It doesn't mean that. I don't believe that's what it stands for.
You don't think that was the intent?
Nope.
No, then they should write the bylaw differently, because right now, it says that he has the right to give me a permit as long as I don't do one of those 2 things. They could have listed 8 of those things, but they listed 2, and it's more lenient than what the state says. I can look you right now and tell you, it's wrong, it's written the wrong way, but that's the way it's written. I'm not adding words, I'm not taking them out. Do you see anything more than those 2 items that section on non-conforming buildings says I have to meet? I mean, it's, you got it, it's there. I don't see any more.
How do you do
I don't see where it says I have to meet
904C?
the maximum stories. Does it say I have to meet the maximum stories in that section?
How do you do, no building area floor already non-conforming shall be changed to being greater non-conformity?
In that section?
No, it's
On a single
904.
2-family dwellings?
C, 904C.
Which is consistent with what it says in the next sentence. Got to read them as a whole.
Bob, our bylaw is a prohibitive bylaw, is that
Yes,
correct? So
correct.
if it's not explicitly permitted, then it's prohibited?
It's not personal, Steve knows this, I just disagree with him. I don't think that because you have one nonconformity in your structure, that means you don't have to apply to anything else, or you can get, by right. I don't think that's what it means.
Again, I'm just reading what's in there. I'm reading what's there for single and 2-family, section 902C. And it is telling the building inspector that you may not issue a permit if the resultant alteration does one of 2 things. Does it say in there the resultant alteration cannot go over the 2.5 story requirement in dimensional density? No.
Well, it's illogical that it would say that because you're not allowed to create a new nonconformity.
You can create new nonconformities if the local bylaw allows you to do it, correct, Bob?
If a bylaw specifically authorizes it, but that's not what this says.
This authorizes him to grant an extension with 2 conditions, that it doesn't do, 1, violate the maximum building area, and 2, violate the yard area regulations. Other than that, and this may be by mistake, okay, but that's exactly what it says he can do. There's no, I'm not mixing the words here, that's exactly what it says, okay? And I'm telling you, that's probably not what they wanted to put in there, but that's what town meeting voted, okay?
Yeah, I just disagree.
That's not what town meeting voted?
Well, I wasn't there when this probably went in, neither were you.
If you were there, they probably wouldn't have said this. Because you would never say, this doesn't make sense.
I would tell them in every circumstance that you're not allowed to create a new nonconformity.
Right, you would have told them that. But you weren't there, and you didn't tell them that.
So that's why I'll tell this board.
So that's how you can have, so that's how you can have it. But I guess it's up to this board to either say, gee, it was done wrong at town meeting, and we want to read it differently, so therefore now we think that you can't create a new nonconformity.
Or it's up to this board to read the rules as a whole and in a logical construction with all statutory interpretation, so that each part is read to modify and/or explain the other. So that's Bob's point.
And that was my point in reading the dimensional
What you did do
requirements
is
first.
you did skip, and the use extended throughout the extended alter. You skipped one phrase in there, and I was wondering why you did that. Any non-conforming 1 or 2 family structure may be altered, extended, or reconstructed, and the use extended throughout the extended, altered, or reconstructed.
Well, that's because that's
portion.
that's irrelevant. I mean, it's a single-family dwelling. So we're still making it a single-family dwelling. Yeah, it's as long as we don't violate maximum building area and yard regulations of the district. And this town passed a bylaw that is more lenient than what the state says.
Yeah,
I'm sorry, but I didn't put the words there. So, you know, again, you can disagree because you don't think it's the right thing, but the proper thing is to...
I don't think it's logical that this meant that, or this was intended to mean, or should be interpreted to mean, that this means you don't have to, you could build a 10-story building, because that's what you're advocating for.
Well, I'm advocating to get over 2.5-story, the 2.5-story
But
requirement.
if the height, I would agree with you, if the height was already in violation of the bylaw.
Our height's not an issue. We're under the height requirements, Bob. This only has to do with the definition of the 2.5 max stories, 2.5. We're
Well-
under the height requirement.
I agree you're under, what, 30 feet or what, 35 feet?
We're under 30.
But you have more than 2.5 stories here.
The issue is the 2.5-story.
How do you
So-
read the other requirements
All right.
there that you can be 3 stories when you have certain additional requirements? How does that
Let
fit
me
into
try it a
your
different way.
analysis?
Okay, let me try it a different way.
Well, you got to answer my questions.
Say it again?
You got to answer my questions.
Okay.
How do you read that 3 stories if the minimum front yard is increased by 14 feet and minimum side yard is increased by 5 feet?
That's
How
great.
does that fit into that?
Neither of those are requirements in section 902.
Yeah, but
They're
now
in the
we're talking
density
about the
requirements.
entirety of the bylaw. You can't go to 3 stories if the minimum front yard, you can go if the minimum front yard is increased by 14 feet and the minimum side yard is increased by 5 feet, neither of which you're doing.
Right, so those are irrelevant, as far as I'm concerned. The only two that are relevant, I mean, is it relevant that my lot area is 10,000 square feet? Could he allow me to do this if I was 9,000 feet? Instead of 10?
He could allow you to go to 3 stories if the minimum front yard is increased by
Right.
14 and the minimum side yard is increased by 5 feet.
Back up just 1 second. Right now, in the table of dimensional density requirements, I'm required to have 10,000 square feet. Can I get a permit from the building inspector if I have a 5,000 square foot lot?
No, you can't
Everything
unless it's
else
a
is-
residential lot of record.
Okay, so there you go. So if it's a pre-existing nonconformity and it's protected, okay, he can give me a permit, correct?
For a house that
Sure.
then complies with
Sure.
certain other requirements.
Okay. So does that have to require with the lot width and frontage of 80 feet?
No.
Oh, okay, so it's protected
50
against
and
that.
5,000.
Does it have to require with a lot depth of 100 feet?
No, but you'd
Well,
still
come
have
on,
to
all these
comply.
things are on the density requirements here,
So-
okay? They're exempt from all of those things.
We can do this at the
okay?
SJC someday, if you
We
want.
could, but the
Your family
reality
will
is,
wait
for
5
this
more
board,
years.
those words are not in the bylaw. You specifically say that if I meet the maximum building area and yard regulations, town meeting voted, we're entitled to the permit, okay?
I think we all get the point.
Yeah.
We can choose which one we think is right at this point.
You can choose.
Okay, so, again, that being said, if that's the intent, then, and you are saying that we now need to get a variance from maximum stories, okay, if we're going over the 2.5, that's what I need to hear from the board, so I could proceed and get to the section of, if you think we need to get a special permit for this, and you can somehow contort this section 902 to say something totally different, then I'm prepared to go forward with a special permit. But again, I suggest you change section 902. Or read 902 for exactly what's on the page. I mean, the building inspector can give me a permit for any one of those 6 of the 8 items. He just can't give it to me for those 2 that I keep talking about. And we don't violate either of those 2. So we either could direct him to issue us the permit for what we want to do, or you can take a vote and we can proceed to talking about the special permit itself. But I need to know whether you would then say that we need to get a variance if we want to go over the 2.5 stories, which is in direct conflict with 902.
I think you need a variance.
I think you do too.
You can give them a special permit for the half-story on the third floor, and everything else is fine. And they can decide how strongly they feel about this. But you can't do it as designed.
You're the hearing
So we
officer.
could, as Bob said, we can give you the permit for a half-story, or,
You can take a vote,
well, we can vote anyways, but
yeah.
it sounds like that's the move from the board, but I'll see how everyone feels.
I like the fact that the chair is still reading this, because she's
I've
understanding
highlighted,
it.
I never highlight and circle things unless,
Read the next sentence.
I am,
That's
and I
important.
am,
Because the next sentence
I-
doesn't include the word building area. It says building,
I think this is a slippery
current
slope.
building and yard regulations. Doesn't say building area, it says
No, it's the
building
whole thing in
regulations.
combination.
That
We can
includes
leave
all
it
the
open to
regulations.
review.
No, I don't need to review, I already know where I'm going with it, but I don't know where, if everybody else does. It's up to you.
Yeah, so let's discuss.
Let's close.
Let's close this.
Well, no, we're not closing.
Wanna
But he wants
close?
us to hear, he wants to know where he stands.
Right,
I want
this
to know
is-
where you stand, you want us to
No,
deliberate
I want
and
to, I
so
want
you
to
can have a
continue. What I
choice?
need the board to do is to first tell me whether or not you agree that the building inspector should issue the permit under 902 for what it says on the black part of the page.
Because then you want to continue with your special
And
permit.
then if the board decides that they do not want to direct the building inspector to issue that permit on that, then I'm prepared to go forward as far as a special permit's concerned. And then Bob has indicated that we would need a variance from maximum stories, 2.5, if we would like to use the whole area up there by special permit. That would create a new nonconformity in our non-conforming building, even though, you
You're
know.
non-conforming, but not as to height.
What we have though is special permit for tonight.
Right.
Correct.
But
We need to
his
decide whether
argument
we want to go forward with
first.
a special permit or you want to continue.
But so
Yeah,
what
once
he
I-
wants
There's
us
nothing
to,
here for a variance, yeah.
he's
So-
not asking Larry,
so
what
he-
he's asking for is us to deliberate, to say, we disagree with his argument.
Close the
And-
public hearing, and then you can
Well, we-
deliberate all you want.
Then we're
He
going,
doesn't
he
want
wants,
us
to- No, no, I
he
wanna
wants
close the
us to
public hearing.
then continue with the special permit. So he's brought an argument that said,
isn't
I
the way it's
believe I'm
done."
interpreting it this way, how do you? And whether, we'll now decide whether we agree with Bob
You'll
or
do it
Steve.
in a deliberation, not
Right.
during a public,
Yeah.
the open
It's
session.
not up for.
But so we'll close and you're in, he's
So I
going to
so I
finish
guess
his
what I should
special
say
permit.
is,
So just a second, sir. So Brian is the hearing officer for this, for
Okay.
this evening. So Brian, it's your call.
Right, but he's got to now present the special permit to us.
right. So that's where I would say, in the alternative, if you don't find a way to say that that's what 902 says, I'd love to see that in part of the decision, the special permit, but I will not ask for a variance to go over the 2.5 story, because I don't believe in a variance for something like this. So I don't think that the board would end up granting that variance. So I think that at that point in time, the board will hopefully grant us a special permit under the same situation as they did for Ocean Street. And there is a plan that's in there which,
Is it Marathas? That's only a half story on the third.
I don't know if you need to have all the elevations or all that for it. I think you've got copies of all of it. But there is a plan.
Getting late, guys.
It's shaded, yeah. Gee, I thought it was going to be really simple.
Yeah. Did you though? Did you really?
I thought I did a really good job explaining that, and Bob will call me later on and he'll say, what the heck did you do there? Because you should change that. Okay, so we've got a plan in there that allows the half-story area at 513.6 feet.
And that's .666. of the-
Yes. Yeah, our allowable space is 520, calculated exactly the same way as they did Ocean Street. We did go over this with
What was
Andrew.
the address for Ocean Street you keep talking about?
50, I think.
Marathas, 50.
50 Marathas. Oh, the 50 Marathas.
Oh, come on, don't do that. The only
just
the
saying,
only
'cause we're
reason
just
I used
tired.
Ocean,
We're
the
just
only
tired.
reason we used Ocean was because at the last meeting, somebody brought up Ocean Street. So we pulled those plans.
Okay, I
Went
get it.
and met with Andrew, found out exactly how that was calculated, did it the same way, and then proposed this plan
We got it.
the same way.
Shaded all in the same
So,
area, showing-
figuring that we were certainly entitled to that permit, and, you know, again, hopefully we turned a few heads on Section 902.
So Rapid had to come for a special.
So is
You
everyone
can poll the,
comfortable
you can
with-
poll the
Yeah,
board if you
but,
want.
you know, if the
Oh, we don't
board's
put it
not,
on?
doesn't issue advisory opinions.
No.
You deliberate when your hearing's closed.
So,
It's
yeah,
up to
all
you,
he-
Brian.
Right, what I'm saying is that he presented an argument for, the first, it doesn't matter, it's all one case. So now we're gonna close this based on the special permit. And then we will then deliberate whether you agree with his argument that he had first, or do we agree with the special permit?
Is he done presenting?
Are you done presenting, Steve?
I don't think, unless the board has any questions
I-
in regards to that
Do
particular
the board
plan
members
that's
have any questions
513.
on the special permit
And the plan.
or the plan? And I make a motion that we close.
Well, I do have one quick question.
Go ahead.
I'm sorry. Andrew, you agree with the calculations for the special permit?
On the third
On the 2.5?
floor.
The only question I had was about the utility room.
Isn't it too big on the third floor to get a special permit?
No, there's no utility room on the third floor.
The calculations of that
Got a
two-thirds.
utility room right there.
On the originals it was.
So is that full height?
That-
And
so
what's
is- they have the
the,
wrong plan up there?
do we have it laid out for where the, you know, where that cutoff is, where the
this
4-foot
Missouri?
line is?
Where the 4-foot line was, it's in the original.
It's this one right here, right?
Yeah, but that's calculated by Ocean Street.
Yeah, calculate it the same way as Ocean Street. We'll hand that to him so he can take a look at that.
Oh, okay. So this is it right here.
Yeah.
Do you have this?
Yeah. I think that's up there.
Is that included with that?
Yeah,
So
we
it is
submitted
different,
with the other
yeah.
one.
Okay.
So then you should have that
We
too.
just got it. Didn't we just get it tonight?
Did this come today?
I saw that shaded, but it might have been,
She's got it right there. They have it in front.
Yeah, she's got it.
Are there two copies, or is this just the same?
No, this is
I
like a
guess the
whole
special
little-
permit's
package.
basically
Yeah.
gonna say that we
Okay.
can have
it
513
can, yeah, it's gonna,
something square feet.
we're going to agree that you can have the .666 square footage of the, calculated by Andrew with the 4-foot knee walls,
Yeah.
the floor below.
I don't have
And this plan meets that criteria that we're looking at from
The
October
shade.
3rd, 2021. Okay,
That's calculated the same way they did the Ocean Street.
okay.
But our language will also confirm that you can't go over it.
Right.
Oh, that's it.
And then you said the knee walls are over 4 feet.
So why
They have to be-
wasn't
they only
the,
start calculating.
how come the utility room isn't calculated in, as part of this?
That's, Mike did the calculations, so I don't know.
Because we went by the same thing that Ocean Street had.
But Ocean Street's in a flood zone, and so they have an allowance under the bylaw to put a outcropping or utility area in the attic space.
Okay, and we can't put AC in that space or anything like that. So we can't use it for air conditioning?
You can, but the other plans show it as a utility room with.
Yeah, which was for the AC. But then, again, it changed
So,
when we were in
but-
front of your board.
Here we get into what's the height in that room, because you have an accessible room, and I need to know the height, because that floor space under 4 feet gets calculated into the overall floor space for the third story.
It's going back.
If it's an accessible room and it's
Going back to the 500.
So 520,
That goes
if
back
it's
to-
520 square feet, everything that is at 4 feet in height begins your calculation of the floor below.
correct.
So what Andrew's saying is that,
So
what
what
we'll
you're-
be saying, if we do this tonight, is that that square footage will be what dictates this plan. So
And
whether
that
your plan
2/3.
agrees to the
And that was my point. If the special permit basically says they can have
520 square feet.
520 square feet maximum,
Maximum of
then
the floor.
we can
Just the
calculate it,
2/3.
you know, calculate it the same way as Ocean Street, whatever. We'll go from there.
Can we vote?
So here's, I mean, so if you could see the two plans, this is where I have the question, right? Is we've got you know, your floor space calculation, including all these areas. But then we have this closet here that's not included, and we have this utility room that's not included. And those need to be included in your floor space calculations.
Right. We'll come back with the 520 square feet.
So you're gonna change your floor?
Have to, obviously, if we're talking two different things, yeah.
So do we want to continue this meeting and await a set of new plans?
That's,
Only if we don't have to have this discussion again.
Can't promise
Like
you
I say,
that.
I can only explain it, I can't, you know.
How much is gonna change it, like, can you?
I mean, I think it's to the benefit of the applicant to have it correctly, the space reflect what you want to do and have it meet the requirement of that 2/3.
Andrew, are you more
And we-
comfortable with us having the correct plan? Or are you comfortable with us saying this plan modified to equal 2/3 of the floor below?
520 feet of.
Meaning they would work with you?
I would be more comfortable with the board approving it. That's the way we've done it. I have not made these determinations on my own.
Approve it at
after the fact.
520 and have them provide the plan.
I would approve it at the 2/3, because I'm
Yeah.
not
2/3,
exactly sure
correct.
that
And
520 is
then you
exactly
will
2/3.
certify when you give the
Oh,
building
I see, you
permit.
don't want the 520
Yeah.
number, you just
Well,
want the
it
2/3.
says.
The
I
2/3,
believe
whatever
it's
that 2/3
514
number
is
is.
actually.
Yeah, so we're gonna certify, we're gonna do it at 2/3, then you're gonna enforce the building code, which is to be 2/3.
Well, it's the zoning code, so.
Zoning, yeah.
But you still enforce the zoning code,
Right.
all right? You okay
But
with-
generally, what we do is we put it, it's on the plans that we approve for these types of situations.
So you want them to come back with a set of plans, we'll leave it open?
I'm just saying that's that would be the consistent
I
way
think
that
that
we've.
that's actually
Then that's what we'll do.
I don't
cleaner
have,
way of doing it.
I just want to say, I'm fine with whatever the board decides. I'm just saying.
I'm okay with that. Is
You're
the
okay with
board,
what? You said many things.
is the board okay with leaving the record open? We won't close tonight, and we're gonna wait on the new set of plans to come in, so we can agree upon the 2/3 of the floor below.
It's fine by me.
Fine by me.
That's fine by me,
So what's our next opening?
24th.
We do have a meeting May 10th. I don't know how many are on there. I think there's 6 or 7.
This should be quick, though, right?
Yeah, this should be quick, so why don't we move them to May 10th?
You have to promise.
Yeah, fair.
You know, I gave my spiel,
We listened.
it's,
I highlighted it.
we can,
So I'm gonna make a motion that we
add
continue
words.
Heard you.
Durkin to 22.29, 75 Marginal Street to May 10th, date certain. Do I have a second?
Second.
All those in favor?
Chris Bellis, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Kelly, aye.
Brian Murphy, aye. We'll see you then.
Thank you.
Dick, you got one more?
Yeah, it's a 2-foot extension on.
That's it.
why didn't you go before us?
No.
Gonna take all this time?
I didn't think it was gonna take that long,
Oh, my goodness.
Well, we'll be in touch.
When,
Thank you guys for your time
Bye.
anyways.
Thanks for the
Drive
education.
safe.
And let me know after you read it, the whole thing.
Okay.
Well, we'll be in
I'm
touch.
still reading, I'm waiting for something to happen.
If I were the owner, it would go to the Supreme Court again.
And if I'm
Dick,
town
so-
council, it will go to the Supreme Court.
What number are you here? What house?
It
like
is.
other business.
Other business discussion?
It's the Anderson project there.
Okay.
Just go with it, Brian.
We got approved.
20,
Yeah, Brian Mandel had turned the stuff in, but he's out of town.
so 21-57, Mark and Meg Anderson, 79 Marginal Street. Petitioners are requesting that the board determine if adding 2 feet to the kitchen area would be considered a minor modification to the petitioners were granted a special permit on August 10th, 2021.
Yes.
Permis, is that a new word?
Is it a change in the footprint? What's going on?
Well, let's take a peek.
See something.
Let's, come on.
What do you got for us?
It's that little yellow area.
Where's it going?
But so now, when you say the little yellow area, is that, if we
That's a
change,
one-story section of the house, but they wanted,
is it in the foundation or is it an overhang?
it's foundation,
So it's a 2-foot extension.
yes.
Where is it, on landing or marginal? I can't tell. Landing or marginal?
The bottom of the page is marginal, the right side is Landings Road. So that's just going into their
The
backyard.
backyard, by the shed, or the garage, or whatever the heck it's called now.
Oh, this is the one with the accessory, yeah. apartment.
deck
right?
extends out beyond.
No, they don't have an accessory apartment, do they?
No
Didn't-
accessory. No.
I thought they, oh, this is the different one, sorry.
So the bulkhead, so it goes out and then there's a
Yes, but that, I have plenty of yard there.
so you're gonna
Back
scooch
that
the
way.
bulkhead further?
Yes, the bulkhead goes with the addition. And above it is a roof deck. You walk
But
out
so
the
you're
second
gonna push that out to equal the other side?
And what's the rear
Is
setback?
that what you're saying?
Where
no,
are
so
we?
Is it go,
He's got lots of room.
16-foot area there.
He's got.
The
Yeah, so
2-foot
right there-
area is right here.
have to look at the.
This
That line
16,
there.
this 16 feet is gonna project another 2
2
feet
feet.
out this way,
Right.
between the porch and the proposed deck. That kitchen area is gonna just come out another 2 feet.
Wait, anytime there's a change in a footprint,
Footprint.
it's not a minor modification.
That's our definition of not a minor modification, is an addition to the footprint. And I only say that because we've always used it.
It's late,
as a
but
standard.
that's how
Footprint, if
we-
I cantilever it, I'm still changing the footprint.
No, you're not changing the foundation. So our original case that we used as a standard was a 2-foot by 6-foot addition to a non-conforming structure, but because they added to the footprint, we felt that that could not fit under the condition of a minor modification. If you slide on a property with maintain the same size,
Right.
we're okay with that. But anything outside the original footprint, even that 2-foot by 6-foot, we felt that was something that needed to be re-advertised.
No, if it was cantilevered, that would be a minor modification.
Then it would be a minor modification.
Because the footprint would stay
Footprint
and the
stays
roof line
existing.
would
Building area
change.
isn't changing.
Foundation and footprint are two different things. I don't
But the-
feel that,
That's
The
our
building
standard,
area-
Dick. So-
The building area wouldn't change, which is the definition of the building area is the foundation walls.
it is.
Yeah, the cantilevered 2 feet over would be.
Is
part of
allowed.
The open space calculation.
Say that again. I know I'm tired. So the cantilever is the open space calculus?
It's
Is that
part
what
of
you
the
just
open
said?
space calculation, and the building area is the actual footprint in the ground.
Okay.
It's just like when you stick jet
Of
stuff
the
out,
foundation.
Yeah, like
Foundation is considered footprint. I've never.
built out
Like a bay window or
Yeah,
anything
bay
like
window.
that, yeah.
It's that same thing. It's that same thing that you get that extra 2 feet
It's
out
just
of.
if we move away from that, I think that we're opening a can of worms for other things
Well, I
coming
think
down
for
the
the
road.
members sitting currently on the board that have been here since 2014, that was the standard we established back then. So, and we spent a lot of time on that.
Yeah.
Even though I'm going in my backyard and has nothing to do with extensions of non.
It's because what we
It's the
presented to the
permitting
public at the
process.
time was what we showed them.
You're right in this
Whether-
particular
But I
case,
come back
but
and you're gonna approve it because.
You understand?
there's no reason not to.
I understand that, but this doesn't fit under a minor modification.
Okay, but I could go ahead and just do a cantilever.
Yes. We
You
can
look at
agree to
the-
a cantilever.
The definition of the building area,
That is a minor
horizontal plane of all
modification.
buildings on a lot measure the outer walls, but exclusive cornices, eaves, gutters, chimneys, unenclosed porches, bay windows, balconies, and terraces.
That's continued, right? Manchester. R2.
yeah, that's in the
So in
text.
that case, actually, you might have a point,
So-
because
so
the outer
then-
walls, yeah.
But so Andrew, which is the one that gives you the one we use
I just never.
to go into the setback 2 feet? It's the,
We gotta make a decision.
it is for bay windows.
That's projections.
Yeah,
Projections.
that's usually when I'm on a side that
No,
we're
that one's
debating
coming
about.
No, it's the front,
These guys.
it's
Oh,
usually.
Did you-
That's,
generally
yeah, that's not, he's not
no
not
choice.
projecting
So we'll-
into a required
move that.
setback.
Setback, right.
To the 24th?
That's more of an issue, because I'm changing something by going into a.
But that 2
That's the
feet,
benefit of the
read
doubt.
that 2 feet description, isn't it, it's less than 50%, it has to be less than 50% of the length.
For a bay, yeah,
No,
but
that's
that's,
on the
that's a,
side.
and that's a different, that's a totally different situation than what we're talking about
If
here.
I'm 15 foot from a 15-foot proper side,
But I think the one we're talking about has to be the
We're
front.
at the limit here.
I guess
This is one of the-
Order here.
We stayed later than this, believe it or not.
Yeah.
All right,
All
were
right,
you guys
so-
good?
What are we doing?
So before,
Well-
are you done with your
Yeah,
conversation?
this isn't a minor modification, so is that what you're asking for, a minor modification?
yeah, you're saying that.
All right, so Are we ready to close?
We're not, we just need to,
No, this hearing.
his was just open business.
Oh, it wasn't, oh, it's nothing then?
Yeah, his was open business, but in the beginning of the hearing this evening, we had a no-show, and that was case 2235. So I'd like to make a motion to, I'll read it into the record, and we'll continue it to May 24th. What do you guys think?
Sounds good.
2235, Dominique C. D'Angelo, the petitioner is seeking a variance in accordance with 305-10.11 of the Marshfield Municipal Code for relief from 305-11.09C6 and a special permit in accordance with 305-11.09 to create an accessory apartment within the soon-to-be-constructed 26-foot by 25-foot addition on the property located at 1230 Forest Street, which is further identified on the assessor's maps as being on parcel D16 03-02 and is located in one zoning district. I'd like to make a motion to continue this case to May 24th at a time certain, 6:30. Do I have a second? Second. Second by Heidi Conway. All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Okay, so that's moved. So we have that going to the 24th. We have Lucetti going to the 24th. And we have Durkin on 75 Marginal going to May 10th.
And we have two
Anything
more
else?
things that are on the agenda. One was a continued one that I have not heard back from 5 Columbia Road.
Yeah, they're on the back there.
Yeah.
Page 4. Can we continue them to the 24th?
Yes. And I've already read that into the record. Yes. So I'd like to make a motion to continue case 2211 for 5 Columbia Road and continue that to May 24th at a time certain of 6:30. Do I have a second?
And I just have one more thing.
All those in favor?
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
Okay, that's continued to May 24th. That's the third one for this evening, going to May 24th.
And what's
Nancy,
the-
what else?
The last one is just to mention the public meeting on April 27th here for Bob to review general 40B guidelines, rules and regulations, but there won't be any discussion
From the public.
about specific projects.
So we were gonna go over rules and regs, open meeting law if he had time, and conflict of interest.
Yeah.
Those are
I
things.
teach a class in all three over multiple nights, so I'm gonna go quick on all those other things, so.
Yeah, whatever you think is the most pertinent to the board and what's coming on in front of us, okay?
I think we should focus on the 40B and I'll get to the other stuff.
That sounds fine. 40B is more complicated at this point and more pertinent to the board. Okay. So that should be maybe an hour. But it would be just
Steve's interesting, huh?
And we'll let you.
Let's
talk about that for a
Let's
while.
finish what we're doing and then you can chat.
That is on the 27th at 6:30 in the Selectmen's Room, correct, Nancy?
Correct.
And you are going to advertise it in the,
No, because it's not a public hearing, but it will be posted on
it'll be
downstairs.
posted so people can show up
And on
if
the
they're
website.
curious on
Correct.
how it works. But there will be no open comment.
Right.
Board comments only, but no public comment.
Yeah, it's just Bob imparting his
Educational.
knowledge on, exactly, Brian.
Cool. Thank you, everybody. I'd like to make a motion to adjourn. Do I have a second? Second by Heidi Conway. All those in favor?
Chris Belazos, aye.
Larry Keane, aye.
Lynn Fiddler, aye.
Heidi Conway, aye.
Brian Murphy, aye.
All right.